ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್? ಹಲೋ ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತದೆ. ಮ್ಯೂಟ್ ಮಾಡ್ಬಿಡಿ ಸರ್.
All matters tomorrow. Not relaxed, not post payment. For what state? Check ಮಾಡಿ ಯಾಕೆ ಬಂದಿಲ್ಲ? Correct, but reach ಆಗಿಲ್ಲದೆ ಇದ್ರೆ we are given the date. Come tomorrow. Yes. Is any adjournment?
Serial number 59 Malan.
54. 2016, I'm sorry. ಇಲ್ಲ 54 ಮಂಜುನಾಥ್ ಸರ್ 2016 ಮತ್ತೆ ದಯವಿಟ್ಟು
My lordship, serial number 59 Malan.
ನೀವು ಯಾರಿಗೆ?
Respondent number 6 my lord.
ಇದೆ. Sorry.
Serial number 59 my lord.
Please don't ask for adjournment.
Serial number 59.
Please wait.
Please.
Anybody else? The number 38. What do you want? You have to intimate the other side. you take the responsibility of intimating the other side, I can grant an adjournment. Otherwise, wait for your turn. This 68. Huh? Yes. At the request of the council for respondent, list on 19th October, interim was extended till the next set of hearing. Anybody? Yes, Mr.
59, my lord. I representing respondent number 6. I intimated to other side also, my lord. Weeks time may be granted, my lord, because senior not held today.
At the request of respondent number 6, list on 18. Is there any interim order?
Interim order, yes, my lord.
Interim order is extended till the next set of hearing.
Much
Anybody else?
Serial number
Correct.
15.
What do you want? Ravisha.
The serial number 59, madam. My brother has taken adjournment.
Yes, next. There is. What is this? Voice is pending. Petition dispose of it. Yeah. Pending. Because it is stated that
Serial 2.
stated that the miscellaneous petition stated that this petition is filed challenging the order passed in miscellaneous petition, which is to restore the suit which was disposed of. Miscellaneous to restore another miscellaneous. To restore another miscellaneous petition which was filed to recall the disposal of the suit. Miscellaneous to miscellaneous. And what was that miscellaneous? Stated that this petition is filed challenging an order passed in miscellaneous petition number 10 of 2004, which was filed to set aside the order passed in miscellaneous 59 of 1994. And that the proceedings in miscellaneous 10 of 2014 is still pending. Huh? Then what is to be?
May I submit, my lord? May I clarify?
The same is challenged. The Villain Council submits that the writ petition has not become infructuous. The submission is placed on record and the order dated 15/9/2022 dismissing the writ petition as having become infructuous is recalled. The writ petition is restored to file.
May I make a submission?
Yes, Mr. Ajit.
The petition was disposed of on the 1st of September 2018, saying that possession of the property has already been handed over based on a bailiff report.
No, correct, but if that is challenged in this writ petition,
Challenge Madilla, my lord, suit itself is.
we'll consider it. We'll consider and dispose of on merit.
Very well.
Corrected only, that is also pending. Correct to dispose agidya. In 1.1 alli, the petitioner has challenged the order. The order dated 1/9/2018 passed in miscellaneous petition 59 of 1995 to stop the Villain Council for the petitioner submit the writ petition service for consideration, and therefore prays that the order dated 15/9/2022 be recalled. In view of the aforesaid submission, the order dated 15/9/2021, the writ petition is restored to file. This for preliminary hearing in the group as per seniority.
Grateful.
My lord, Sam for the petitioner in this case. I filed a NOC Wakalat before that, my lord. Here, my lord, here, OS number 218 of 2016 is pending, my lords. But the court has observed that 218 of 2018 has been placed, my lord. That is the only mistake.
The Learned Counsel for the petitioner submits that this court had disposed of the writ petition as having become infructuous on the ground that OS number 218 of 2018 was disposed of, while in fact the magistrate put up the case status of OS number 218 of
2016.
2016. So in view of the apostate submission, the order dated so and so is recalled and the petition is restored to file. What about this process?
Let's process today. I'll pay, man. One submission, my lord. In the before the trial court, my lord, they filed an application for dispersal of amount. Dispersal.
Wait, mister.
Please. I'm sorry.
The process paid during the course of the day, office is directed to proceed to issue notice to the unserved respondent.
The trial before the trial court, they filed an application for dispersal of the amount, my lord. The 1 acre is concerned, my lord. The rest of the acres.
Please move it first. Pay the process and move for whatever stage you want.
Please. Which of that?
218 of 16. Sorry. 218 of 18. 16 is 18. Next. Rajinikanth Ellis. Sure, what is the CPC matter? First, you should open your argument saying, what is the suit for? What is the application for? First open sentence should be this. The GMCPC, please understand, this should be the opening sentence. Suit is for this, IA is for this. The suit is for partition. What is the application now for? What is the application IA 33? Who has filed it? Second defendant. What stage? Reward amount. What reward amount? Where is that application? Yes. Where is the application, sir? When did you insert this additional property? 2015. Yes. Issue notice. In addition, the learned counsel for the petitioner is directed to serve the learned counsel who represented the respondents before the trial court. In the next date of hearing, the impugned order dated so and so is stayed. This time. Yeah. At what stage? This is what stage this application was filed? Issue notice, further proceedings, issue notice, same or learned counsel for the petitioner is directed to serve learned counsel represented the respondent to the trial. Until the next stage of hearing, further proceedings in US number so and so on the file of the so and so court is stayed. List on.
Arrears also pending. This vengeance of arrears going on, and then the discuss what is filed and everything went on. Everything yes, the judicial
Are they still pending?
still pending. They should be there. Are they making it over 215? It's going on. But no question the everything proceeds now.
I think FDP nadile bidu ಏನಂತೆ
Doesn't mean honest. It really administrative on.
FDP nadadre ಏನಾಗುತ್ತೆ
Going to execute the decree going wrong.
FDP is already drawn, final decree is already drawn.
After it.
The final decree draw ಮಾಡದೆ execution ಹಾಕಕ್ಕಾಗುತ್ತಾ ಅಲ್ಲಲ್ಲ please tell me, can the final decree be executed even before the decree is drawn? Listen, this is only FDP. This is only FDP. No execution ಹೋಗಿಲ್ಲ. FDP ಆದ್ಮೇಲೆ there will be something called a final decree. Decree ಆದ್ಮೇಲೆ ಆ ಡಿಕ್ರಿನ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಮಾಡಿ ಪೊಸಿಷನ್ ತಗೊಳ್ತಾರೆ. ಫೈನಲ್ ಡಿಕ್ರಿನೇ ಆಗಿಲ್ವಲ್ಲ ಇನ್ನು. You file an application in RA. RNL application file ಮಾಡಿ drawing up a final decree is stayed ಅಂತ ತಗೊಳ್ಳಿ. RNL stay ಇದೆಯಾ?
But technically they are not showing in ownership.
Where is the order sheet?
There is none, I think.
In RA.
It should be page number 42. See the entire policy there.
ಎಲ್ಲಿದೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಎಲ್ಲಿದೆ?
Page number 16, I think is there. It is not table, I think is there.
Page number 60.
60, right.
Memo reporting death of R3, no LRs. R5, no LRs. R13, daughter and wife are on record. Objections, if any, So really the stay and move an application before the appellate court for stay of the final decree, drawing up of the final decree. Parkul. You have anything else to say? ತೊಂದರೆ ಏನ್ರಿ ಆಗುತ್ತೆ? ಏನ್ ತೊಂದರೆ ಆಗುತ್ತೆ ಹೇಳಿ? Basic question of execution, mister. There is not even a decree. Execution ಎಲ್ಲ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ. Dismiss ಆಗುತ್ತಿದೋ? Please argue. Take your time, please argue.
Liberty to file application before the RA. The RA is the pending remand, not your.
Sir, RNL application, you could have filed an application in the regular appeals. You could have filed an application in the regular appeal for stay. Yes or no?
That is pending, that is highest pending.
Can you not press that application before the appellate court?
You know, the third part is also filed an application to increase them and taking also the center on this order. The third part is called application.
Mister, you are the defendant in the suit.
I am responding.
You are the defendant in the suit. You are the defendant in the suit. You have filed the RA. Some third parties have filed an application to come on record.
Because exactly RA, FTP allowed. Even the course of the.
Therefore, should you not file an application before the appellate court for stay of the proceedings?
I am pending it, sir. Seeking stay of the proceedings, sir.
Yeah, why don't you understand what is the, whether this writ petition is maintainable or not? Can't even you apply your mind? Before filing the petition, will you not apply your mind? ಯೋಚನೆ ಮಾಡೋದಿಲ್ವಾ? Mr. RA applications pending ಅಂತ ನೀವೇ ಹೇಳ್ತಿದ್ದೀರಾ? You press ಮಾಡಿ. Press the application before the appellate court. Without pressing the application before the appellate court, how can you now come and challenge the proceedings before the final decree court? ದಯವಿಟ್ಟು ಹನುಮಂತಪ್ಪನವರೇ, please apply your mind before filing. File a pick water, the petitioners were the defendants in voice number 45 what is also voice number 45 of 2009 who suffered a preliminary decree of partition and later challenged it in an appeal in RA 92 of 2015 to stop. The petitioners have filed this petition and challenging the final decree proceedings initiated pursuant to the preliminary decree in OS 45 of 2009 on the ground that the final decree court could not have moved further until RA 92 of 2015 was disposed of. Next para. Since the petitioners have already approached the appellate court in RA 92 of 2015, it is open for them to seek appropriate interim relief in RA 92 of 2015. But they certainly cannot come to this court under Article 227 of the Constitution of India to set at naught FDP 5 of 2018 on the ground that RA 92 of 2015 is still pending consideration. That way of the matter, this petition lacks merit and the same is dismissed. It is open for the petitioners to file appropriate. It is open for the petitioners to pursue the application, if any, filed in RA 92 of 2015 for stay of the proceedings. ಇಂಥ ರಿಪಿಟಿಷನ್ ಹಾಕಿ ಡಿಸ್ಮಿಸ್ ಆಗೋದು. ಸಾರಿ, ಯೋಚನೆ ಮಾಡಿ ಹಾಕಿ ದಯವಿಟ್ಟು. Pardon? Issue notice in addition so on so on. List on date put. MB Chandrachuda. At the stage of arguments, what has happened? What has happened to the application? Allowed or reject? What is this document? Huh? What is a suit file? For partition. But then why you stepped over? Why the written statement was filed belatedly? First, issue notice. In addition, learned counsel for the petition is directed to serve the learned counsel who represented the respondents for the trial. Subject to payment of cost of ₹5, subject to deposit of a sum of ₹5,000. The further proceedings in invoice number 46 of 2012 state it is made clear that this amount deposited by the petitioner shall be utilized to pay cost if necessary to the respondents. The amount shall be deposited within a period of 1 week from today. This code. 1 week, sir. So I should be party.
The edicts on the issue where are remnants in Mysore, 2016. And the property was said that there is a in Mysore.
Your suit is also for partition.
Yes. And also the discussing application saying that it may right of the party will return in Mysore, but the binding on that is
Are the suits before the same court? We will call that both the suits to be called together. Therefore, will that So therefore, we'll directly go to call both the suits together, so that you will know if there's any compromise, you can always oppose. Who has issued notice to you? Has the court issued notice to you? Then why did you file the wakala?
Should be there.
OS 10, where is your suit? OS number 846.
But they need the government to be just like that the defendants in my suit. To be claimed not in the subsequent suit. But
Where is the subsequent suit 2019?
yes, they also find a connection B. But I think it is right.
Narayana.
397. Refer to the suit.
Just a moment. Chandrasekhar. Yeah.
This is the adjudicator and two property in the 9.
How are you related to these parties? Who is this Chandrasekhar and Chandana? And who are they? Chandrasekhar and Chandana, who are they?
And they are partially my she is no more. No more. Therefore, having not made party nice. It must be anything is subsequent so.
Properties are the same.
They 97. I told you subsequent so. 87.
Good God. Yes, Mr. What's wrong? Why they should not be implemented? Vacation ಇವಾಗೇನೆ ಬಂದಿದೆಯಲ್ಲ Mr. You have filed the wakalat. You have taken the risk of appearing before the court. Please tell us. So why did you file the wakalat? Then argue. You will stay it then. Hold. There is the risk of filing the wakalat in advance. You don't even know what this case is to file the wakalat. Good. Mr. What's your name? Mr. Shashank. You have filed the wakalat. Mr. Shashank accepts notice for yaru respondents 1 to 3. Issue notice to the other respondents. 1 to 3. Office is directed to show the name of Mr. Shashank. You have any initials? Star Shashank. Star Shashank in the cause list. Issue notice to the other respondents. till the next date of hearing, comma, further proceedings in OS number 1061 of 2019 is state. List on. Huh? At the stage of issues are framed or not? What has happened? On what ground?
I fought for us community that also the release for identity. Both the door was the return of the
Yes, issue notice. In addition, land counsel for the petition that to serve the land counsel who represented the respondents to the tab. Please take out notice first. List down and date put. Please, suit is for what? Suit is for recovery of rent.
One property. So in the agents of my property. Understand. Documentation. Well, take an additional suspension. Also paid additional rent. No need for regular. Provide an application.
This is between brothers. Is there a possibility of settlement?
You should get to one once these funds. Matter is also for evidence. Therefore, I'm supposed to be.
What is the application now filed? What is the application filed now? What stage this application was filed? At what stage? Workload issue notice. Additions also soon. Is the next state of hearing, further proceedings in OS. Commercial OS 882 of 2021 pending on the file of 10th additional 11th additional district and sessions judge Bengaluru. The state this term 21st October. Yes.
Sale was confirmed on the 17,2005.
There's an auction sale. Was there an auction sale?
he has been not having any for the property. He is relating his only to the
Hmm.
and he respected the proceedings. Based on the
What is the suit for? Hmm.
and the defendant did not pay the amount. So I filed execution. With the execution, and the property was brought to was attached and not right. Maximum of the case. We did not deposit the amount. Therefore, the action did not happen. Then the government was reported to bring the amount and pay the entire amount of the whatever also to stress. And then after started to be reviewed the rates, because then that was the property.
So you're entitled to the money, isn't it? Then put it, good quote जमीन बिल्कुल
Sales certificate was confirmed on 19th.
Hmm.
And the sales certificate was issued on 27/1/2006.
Hmm.
There is not that for execution of that lot was filed on the 30th of August 2013. After lapse of 16 years.
No, you had an option. You had that option.
The application seeking possession of the property is filed under Article 134 of the Litigation Act. The possession has to be taken within 1 year from the date of stay being become absolute. So therefore, on that count, my lord, I objected the execution proceeding. The right well settled below the unknown Supreme Court of health. But the only recourse to the debtor that is very approved. Allow the first respondent has already filed a proof that he has not
What has the executing court done now?
Special court has said that I have purchased the property during the pendency of the proceeding. But I have the date of the CDV. There was no litigation pending. So the execution was also over. Procedural proceeding was also over. So there was not the execution was not after that this execution proceeding.
When did you buy? When did you buy?
But I purchased it in the year 2006 itself. 7/7/2006. 7/7/2006.
What is the date of the decree?
Date of the decree is 25/8/2001.
25/8?
25/8/2001. And we got the execution petition was filed on 22nd of July 2002.
22nd of July 2002. The execution is a continuation of the proceeding.
No, execution got ended on 17/12/2005, and the same was confirmed by the court. The EP was closed.
Was there no attachment?
There was no attachment.
Where is the order? What is there to show that there is an attachment order? Paragraph number? Page 54, is it? Page 24.
Area number 2 going to be where? Sold this property, you have area number 2. Where certificate was also issued to the court.
This must be, if it is attached, how did you purchase?
The sales certificate was issued on
27/1/2006. And you have purchased it thereafter. What is your right? What is your right? So what is your right to challenge is what I am asking. What is your right? The property which is a subject matter of the execution proceeding is attached, sold to the decree holder. You have purchased it after that. What did you purchase?
And the subject matter of the execution proceeding is a house property, which is situated in the middle of the.
So that is your problem. That is the problem that you have to face. So you have only one option. If you want to retain that property, pay the money. That is the only option you have.
I have raised two. There is the corresponding hearing. The place on the 12 of 2012, the proper as the agricultural land of the son, and so far as the subject matter of the execution proceeding is concerned, there is no property. The Supreme Court has clearly said that there are high possession of the property. However, there are high ways of possession to be taken. So, there are high sufficiencies. Now, if at all the decree holder wants to take a possession of the property, through the due process of law, he has to take, not by report, having recourse under the law, as a 85 of things.
No, it is attached. Property is attached. If it was not attached, what you have said is right. The property is attached.
We should clearly say. Providing for procedures for renewal of property in occupation to the requires an application be made by the applicant for renewal of property. In respect of which the certificate has been granted the rule 82 of our code. There is nothing in rule 95 to make it implement for the applicant to follow the certificate of on the same being absolute, the application on the code. Both issuers say that may for any reason today, whether there is a failure to issue the certificate or delay of action on behalf of the court or the inaction of the procedure is completing the legal requirements and formalities or factors are no bearing on the limitation for the purchaser cannot seek to extend the limitation on the role that certificate has not been issued. It is too low. That order for renewal of possession cannot be passed unless the certificate is issued. It is manifest therefore that the certificate is not coming from of the application. These both these matters are in the main court. The starting point of limitation for the application being the date and the sale becomes absolute. There is the date on which title passed. The evidence of title in the form of sale certificate due to the court will always be supplied later to the court as per the requirement of Article 51 should be required. Then which is a pointer. It is therefore becomes clear that right of the court option for procedure becomes complete on the confirmation to sale under Order 21 Rule 82 and by virtue of the first of section 65 CPC, the property held in the procedure from the date of sale. The certificate of sale by itself, not creating title by merely address thereof. The sale certificate, as it is a formal acknowledgement to the fact already accomplished, stating as to what to sold. Such act of the court is.
No, please tell me when it was attached, when the property was attached. When was the property? What is the consequence of attachment? What is the consequence of an attachment? No, what is the consequence? What is the consequence of an attachment of the property?
Once the property is not covered and it is sold, pursuant to the attachment of the execution protocol, the execution proceedings come to an end. by way of once the sale is confirmed, the execution proceeding comes to an end. That's what the article of the trial court also raised.
Please tell me what is the consequence of an attachment in an execution? What is the?
Attachment of the property only subsists if the property is not auctioned for and the sale is confirmed.
Yes.
And once the property is sold, by submission is that the nature of attachment comes to an end because the title in the property which is brought for the auction is sold. Therefore, the attachment ceases to exist even after issuance of the sale certificate. That is my respect to submission. Therefore, the subsequent paragraph where the sale in paragraph number 13 of the same date.
Please read Order 21 Rule 95 for a moment. Good.
Where the immovable property sold is in the occupancy of the designated or of some person on his behalf or of some person living under the title related to a designated subsequently to the attachment of such.
So you fall within this?
Yes, sir.
You fall within this?
I fall within this.
No.
And a certificate is registered thereof has been granted under Rule 94. The court shall, on the application of the purchaser, order delivery to be made by putting the purchaser or any person whom he may appoint to receive delivery on his behalf in possession of the property, and if need be, by removing any person who refuses to vacate the seat.
Limitation.
For delivery of possession by a purchaser of movable property and sale in the execution of a decree. The period of limitation is 1 year. Then the sale becomes absolute. But the sale becomes absolute once the order of confirmation is made by the execution. In the case of hand, the sale became obsolete in the year 2007. And the sale was confirmed. On 17/12/2005.
Sale was confirmed on that day. Yes.
17/12/2005.
Yes. When was the application filed under 21 Rule 95?
2017. 30th of August 2017. So after lapse of 16 years, the application is made. Therefore, the application is all the limitation. Article 132 of the Limitation Act.
Till 12 years it is done.
It's not 12 years.
17/12/2005 and 38/2017. That is within 12 years.
Yes. 12 years.
Or within 12 years. Oh.
So that's why Article 132 will not be.
Yes.
There's no independent right for interest in a whole. Each right is only driving the one. Therefore, and no right to obstruct the
Yes.
law.
But then why do they use the word on his behalf or some person claiming under a title created by the judgment debtor subsequent to that 95 only? Why do they use the word? Why do they use the word or of some person claiming under a title created by the judgment debtor subsequent to the attachment to such property?
Now, Lord, this is okay. on the area of the
Hmm.
search of the property.
Forget that, forget that. Why didn't the executing court not apply section 3? Forget the case of the judgment debtor number 2. Why the court did not apply section 3 to find out whether the application order 21 rule 95 is within time or not?
They would have also contested the matter with the lowest level of some men. So it is quite a property. Why there is delay on the court? From getting sales certification in the court, that they would have tried to take lower of property. Can see the market of the area, look at the market of the market. Area of the police was prepared in part of the sold the property in the area number 2 was certain risk. As a manager,
Was there any order of injunction in OS number 12 of 11? Injunction itta lenadru. 12 of 11 lane order agitta. Stay of execution. Yes, Mr. Yes. You want to pay and buy peace, or you want to lose and fight? Pay is money, Mr. Correct, you take. Correct, you take money, pay money and take back the property. Otherwise, you lose it. Better you pay the money and please retain the property. You can't get it for a song. When you knew that this property is involved in a litigation, why did you pay the money to the judgment debtor? Number 1.
But I was sure to the month of February 2006 because we also did not have the knowledge about possession is not really
Just get instructions. If you want to retain your property, if you want to retain the possession, pay up. No. Please get instructions. Please get instructions. Sir, I'll post it tomorrow if you want. Please get instructions. I can't keep it pending. I can't keep it. No. Tomorrow. Just tomorrow. First ಹೇಳ್ದೆ ಮಾಗುತ್ತೋ ಇಲ್ವೋ ಅಂತ ಹೇಳಿ after tomorrow. Who has filed this application? Make sure see. What has happened? So you have taken the risk of purchasing this property. Why you want to know whether? Right, you have purchased this property. If you don't want to seek for alternate relief, if you don't want this property, seek for the alternate relief of refund. Sir, you have purchased a property, right or wrong, which has a Rajakaluve. Then why should we go to find out whether there is a Rajakaluve? You tell us whether there is a Rajakaluve or not. Kaluve then can't be enforced. Or even if you buy nothing.
Assuming that I have to purchase the property.
Very bit buddy. Right. You want to buy the property, you buy it as it is. With the Rajakaluve, without the Rajakaluve. These are.
All these aspects are discussed. However, inquiry
the site measures only 40 by 60. So the entire thing falls within the Rajakaluve. If you say that once it falls next to a Rajakaluve, then everything goes Mr. You can't use it for any purpose. Therefore, you can't. Even if you construct, the BVMP will come with the bulldozer. Purple. You seek for alternate. Purple. At any stage of the proceeding, you can file an application for alternate. You not memo the application of allow section 22. You can file at any stage. The petitioners for the plaintiffs in OS number 6482 of 2015 on the file of the 42nd additional CPC in Sessions Judge Bangalore have filed this petition challenging the order dated 6/9/2022 by which an application filed by them in order 26/9 of CPC was rejected. Extra, the suit in OS number 6482 of 2015 was filed for specific performance of an agreement of sale. Section 25/7/2012. To stop. The defendant attested can claim that the plaintiffs are not entitled to the relief of specific performance. After the suit was set down for trial, after the conclusion of the trial, and when the case was set down for arguments, the plaintiffs allegedly realized that a Rajakaluve ran through the suit property, and therefore the plaintiffs filed an application under order 26/9 of CPC to conduct a local inspection and to ascertain whether a Rajakaluve ran through the suit property or not. The said application was opposed to the defendants. The trial court, based on the contentions urged, rejected the same in terms of the order dated 6/9/2022, which is challenged in this petition. Next, the learned counsel for the petitioners / plaintiffs submitted that the defendants did not disclose that a Rajakaluva ran through the suit property, and therefore it is necessary to obtain the report, necessary to obtain the said necessary to ascertain the said fact through a local inspection. Full stop. If the petitioner has purchased a property with eyes wide open, and in terms of an agreement of sale, which he intends to enforce in OS number 6482 of 2015, he cannot backtrack and contend that a Rajakaluva runs through the suit property. Full stop. If it does, he has taken the risk of purchasing such a property. Therefore, the only remedy to which the plaintiff is entitled to is to seek for refund of the sale consideration allegedly paid under the agreement of sale. Full stop. The trial court was justified in rejecting the application. There is no error committed by the trial court in rejecting the application. Therefore, the resolution lacks merit and is dismissed. Yes. Subject to the observations made above. Subject to the observations made above.
Please, my lord, am I audible to your lordships, please?
Yes, yes. Loud and clear. Please go on.
Please, my lord. And registry be directed to delete my name, and my colleague is on VC, Purnima S. Her name be shown, my lord.
Office is directed to delete the name of Mr. S.S. Yadrami and show the name of
Purnima S. is my colleague, my lord.
Purnima, yes.
Yes, he understood.
Yes, I heard you. Please wait. Show the name of Srimati Purnima S. as the counsel for the petitioner, the cause list. What about this process 2016?
My lord, I undertake to appear for the petitioner, my lord.
Yes, madam.
My lord, I undertake to appear for the petitioner and I will file wakalat for the petitioner, my lord. Kindly grant 2 weeks time to take steps, my lord.
2 weeks time is granted to pay the process in respect of the unserved respondent, failing which the petition shall stand dismissed.
May I pray, my lord, the counsel for the petitioner.
You have no voice. You have no voice now.
Please.
Purnima has taken over. You have no voice.
Please, please, please. Oblige, my lord.
Joint counsel for the petitioner has filed a memo stating that the petition filed a memo to withdraw the petition since the suit from which the present petition arises was disposed of. In view of the above, the petition is dismissed as withdrawn. Right, that was the money down. Close again. Next.
One question.
Process. What is this, Mr. Imran? Whatever this process to issue notice on IA 1 of 1 to counsel for the petitioner takes time to take steps to pay process to issue notice on IA 1 of 21 to 3 of 21. 1 week time is granted to do the need, failing which IA 1 to 3 of 21 shall stand rejected. Yes. Interim order is extended till the next day. Non-failing of crime paid cost to 1,000. What is this 1,000 rupees cost is not paid? So please pay the cost today. Password. Please pay the. Yaar kodbeko kodli. Who has to pay?
Okay, for the and for the
Who Whoever has to pay the cost, let them pay. Yes, Mr. Abhinav Anand. Abhinav, his colleague was here. Password. Let us get our due. Yeah, cost कटक 100 रुपये. Learn counsel for the petitioner, respondent submits at the cost of ₹1,000 is paid today. Arbitration has become infructuous. What is that a fact? What appeal in RFA? When did R2 die? RFA file code 24 June 21. Office to 1,000 rupees ಆಯ್ತಲ್ಲ, office to check and verify. 16 ಅಪ್ಡೇಟ್ ಆಗಿದೆಯಲ್ಲ, ಅಪ್ಡೇಟ್ ಆಗಿದೆ ಬರ್ಕೊಳ್ಳಿ. ಇದು 16.1 ಅಲ್ಲಿ R2 ಅಪ್ಡೇಟ್ ಆದ್ರೆ ಎಲ್ಲ ಮೇಲೆ ಅಪ್ಡೇಟ್ ಆಗ್ಬೇಕಲ್ವಾ? ವಾಟ್ ಇಸ್ ಚಾಲೆಂಜ್? The setting aside abatement ಆಗ್ತದೆ. Since the appeal, since the 16.1 alama, since the appeal has abated against R2 and the judgment in decree against R2, and since it said, and since the composite judgment and decree is challenged in this appeal, the abatement of the appeal as against R2 should result in abatement of the appeal in its entirety. Hence, the appeal is disposed of as having abated. Well, an application. Ah. 2019, you have the password. Please do it today. The process code is 57, R5, R7 and R9. How that is code? Whatever it is, please do it today. Process code first. Password. Yes. Now let us see what is challenged in this.
Of the review of finality order. But earlier petition was filed. What happened is that we are asking that I should get this share as well as not been amended.
Then you file an appeal. There is an appeal provided. There is an appeal provided.
Similar situation this one will not get once a preliminary decree is passed, the final decree cannot be made as final decree. But that order was not ultimately not set aside by the court. Now the order 6 SEC page 464. But that court has said that once the law is amended, the shares not as per the law has to be granted or even final decree.
That is a law declared in Priyanka. Vinita Sharma also.
Yes. Now, as per that, if I can find the application to final decree court. Final decree court rejected it saying that I will calculate shares only as per not the preliminary. That was challenged because this was the report number 14067 of 2011. And this was the report not granted because it would file a review. Accordingly, a review was filed. And that order was at 152, not the option C. But the reasons right and evidence of course, law does not provide for review of the order. Respondent number 7 has some sort of withdrawal of the no order passed by the Honorable High Court of Board. Attention to those aids in the law RX number 716 as per section 6A of the English respondent number 12 will not change anything. But it is not required, but even if the SPP would have been granted. Therefore, not.
Then that's a ground for appeal. Under 227, how can we sit and set aside a final decree?
And the allegation was under 152.
Where is
Here
that?
also the application is under 152.
Where is that order? 14037. Seeks leave of the court to withdraw the writ petition with liberty to seek review in accordance with law.
Accordingly, the review was filed. That is
Right. You taken the risk of filing a wrong proceeding.
The application was under 152. The option to kindly have not been
123.
everything was very much pending.
123.
Yes. Petition is filed for partition. But then you also to kindly see. Page 128. The temptation of the plaintiff is that the claim of error is already decided next time. The seventh defendant has not denied that she parted to the RSA. However, we have much to indicate that second amendment the article into this is good for action and agreement to accordingly, the plaintiff to regular decided on 17/8/1996 by the time the amendment and taking into consideration this amendment. Appeal was disbursed, therefore, plaintiff completed draft is designated again cannot be suspended. The other entity is to the Honorable High Court. I am disposing of the share confirm the regular second
But you are absolutely entitled for a share, no dispute.
No, but the share that is granted is as per section 8, not in the father's litigation part. That is not after the amendment is acted.
You are entitled for a share, no dispute.
Share, I am getting.
Whether you can file a writ petition is what is the question. When you file a writ petition is the question.
But against the order by which the review is not rejected, because I had filed a challenging, but I have filed applications to amend the decree not as per the law. And you see the order in the second appeal. Page 17. Page 17. Page 36. Also, you see the paragraph. The second appeal therefore allows the Interim that the interest branch representing direct profit shall be entitled to one share, share, and one third share of Dodra land shall be divided between the branch of direct profit of $5. I directed the finance to calculate the share. All the participants in accordance with law are conducting inquiry into that effect alone and incorporate the share. However, in the final decree, I filed an application that I have to be granted share as per the mandate section 6A. That has been rejected. Therefore, I am before this.
But you and your uncle and your father are two brothers.
No. I am daughter of Dodramaya.
You are the daughter of
I
Dodramaya.
am daughter of Dodramaya. I am married daughter. But Narayan Swami and Krishna Swami are my brothers. They get one third share. In the one third share, I am given a motion
That is why I said you are entitled for a share equally that of a son.
That is correct. But that the FTP court can do is what the Supreme Court has done.
Absolutely. He could have done.
The FTP court.
Now, therefore, the FTP court is disposed of the proceeding.
Disposed of without considering my application.
That is also considered.
152
152 you have filed. That is rejected. File an appeal. File an appeal. That is the only way. You are entitled for a share. I can't dispute that because the law says change in the position of law will always have to be taken into consideration while drawing the final decree. ಯಾವ್ದು ಇನ್ನೊಂದು ಯಾವ್ದು is that Shesha Sai Reddy, no? Which is the judgment? Sai Reddy. It was considered in Vinita Sharma.
So that is not the same amendment to the Central Act.
Right, but in that case also, the question was whether changing the position of law can alter the shares.
Under the shares.
So the court has said it can.
When the FTP was proceeding, when it is not attractive.
You are entitled, absolutely entitled for a share.
Now just because the FTP has been closed, like how many more active the shares? It will not go to
You have to file an appeal. Under 227, you can't.
This is not unfair on this. Because when the law is brought into notice, then the court says that I will only consider as per RSA. That is not wrong.
No, it is unfair on the part of the advocates advising her also. In 2011, FTP is closed. And you allowed this lady to wander from pillar to post from 2011 to 2022.
But remember, liberty was granted in this. Finally,
Liberty was not granted by this court. You said that you will go before the court. Court said, okay, go.
Liberty is not for it granted.
You asked for it, the court said, okay, if you are entitled, take it. Barkul. The petitioner was one of the defendants in OS number 14 of 1986, which was filed for partition and separate possession. Full stop. The said suit was decreed, and it was declared that the petitioner was entitled to a share in the notional share of her father by virtue of Section 6 of the Hindu Succession Amendment Act 1956. Full stop. This position was confirmed in RSA 716 of 1995. Full stop. Consequent to this, FDP 1 of 1999 was filed to enforce the preliminary decree. So during the pendency of this final decree proceedings, the Hindu Succession Amendment Act 2005 came into force. Yavaga? Hello, when was it? 1998 RSA. 1994 Act. You're talking of the 1994 Act or the? During the pendency of the regular second appeal, the Karnataka Hindu Succession Amendment Act 1990, Hindu Succession Act bracket Karnataka Amendment Act 1990 had come into force. Full stop. Following the preliminary decree, final decree proceedings was initiated in FDP 1 of 1999. The final decree court held that the petitioner is entitled to the share that was declared in RSA 716 of 1995 and declared that the petitioner is entitled to 1/5 share out of the 1/3 share of her father. Full stop. The petitioner thereafter filed an application section 152 of the Code of Civil Procedure to review the judgment and decree, review the final decree on the ground that on the promulgation of the Hindu Succession bracket Karnataka bracket Amendment Act 1990, she was entitled to claim on par with the son and was therefore entitled to 1/3 share along with 1/3 share. There are 5 daughters, 5 sisters. She was the only one entitled to 1/3 share in the suit properties as she was then not married. Full stop. The application filed under section 152 was also rejected in terms of the order which is impugned in this writ petition. Full stop. The learned counsel for the petitioner submitted that the final decree court was bound to take into consideration the change in the position of law while declaring the shares of the parties. Full stop. In this regard, he relied upon the judgment of Prema versus Nanjegoda. So on so. Stop. Next para. The question whether the shares declared in a preliminary decree could be altered by the change in the position of law is well settled, not only in the judgment cited by the learned counsel for the petitioner, but also in the judgment of the Honorable Supreme Court of India, Vinita Sharma versus Rakesh Sharma. Full stop. There cannot be any quarrel on the aforesaid question of law. However, the question that arises for consideration in this petition is whether the petitioner is entitled to file a petition under Article 227 of the Constitution of India, challenging a final decree proceedings. Full stop. The answer to the said question is in the negative, as an appeal is provided under Section 96 of the Code of Civil Procedure. Stop in that way of the matter, this petition is dismissed as not maintainable. It is open for the petitioner to file an appropriate appeal challenging the order passed, challenging the final decree drawn in FDP 1 of 1999, as well as the order passed by the final decree court rejecting the application in section 151, 152, and 153 of CPC. Full stop. It is needless to mention that if an appeal is filed, the time consumed in pursuing this petition shall be enlarged while calculating limitation. Office is directed to return the certified copy of the impugned order to the learned counsel for the petitioner after retaining a photocopy. Yes.
Share was given under section 6.
Meeting other.
Motion of partition is under.
No. Hindu Succession Act. Before the amendment, if he leaves it behind female heirs in class 1, then it is notional partition. No. Let us see section 6 before it was amended. Co-personal. Otherwise, how are you entered? No, please have a look at section 6 first. For the amendment. If he leaves behind female heirs in class 1, then it becomes notional partition. So if he is dead, where's the question of assigning him notional share? Next. Non-compliance of office objection. Amendment plain to be furnished, annexes C and D to be attested. Annexes C, D is noted. Please comply. Then amended plaint is not furnished. 1 week time is granted to do the meeting. After service of notice to a respondent number 1. In the next set of rules. Yeah, that's all for deposit. Learned counsel for the petitioner submits that the order dated 3/9/2022 is complied and a sum of rupees 10,000 is deposited. Just after service of notice to R1, interim order extended to the next step, number 20 amount. Yes. R1. What's your name? Mr. Girish. Girish? Girisha TR. TR. Mr. Girisha TR accepts notice for respondent number 1. Office is directed to show his name in the cause list. Yes. Ready? Learn counsel for the response each time. This on 20th October. Interim order is extended till the next date of court. There are R2 here. R2. What about R2?
$22, my lord.
Yes, 22.
I have filed my wakalat, my lord. My name is kindly soon. Next bit.
Ramesh Chandra, initial enough.
Initial. Ramesh Chandra.
Ramesh Chandra is accepts notice for respondent number 2.
I already filed wakalat, my lord.
Mr. Ramesh Chandra submits that he has entered appearance for respondent number 2. Office is directed to show the name of Mr. Ramesh Chandra as the counsel for respondent number 2 in the cause list. Yes. Ready?
Next week, my lord.
Sir, are you ready? The request of the counsel for the petition this next week. Interim order, yeah? Interim order is extended to the next date of hearing.
Lord, last date of hearing, your lordship's directed issue of notice, my lord. There is no interim order, my lord.
List after service of notice to the respondents.
Please, my lord, publish.
Same order. Yaru. K.C. Nagaraj. Huh? Mohidun Shah. Mr. So-and-so accepts notice for respondent. The office is directed to show the name of so-and-so as the counsel for the respondent in the cause list. Interim order is extended to the next date list on 20th October. A memo for withdrawal is filed.
I filed for petition.
Withdrawal of the petition is filed.
Yes, ma'am.
In view of the same, the petition is dismissed as withdrawn.
Yes.
What is this liberty to file CRP?
Yeah, my lord, because 7 Rule 11 was rejected, and based on that CRP.
A memo is filed by the learned counsel for the petitioners stating that the petition is not maintainable and therefore seeks permission to file a civil revision petition. In view of the memo, the petition is dismissed as not maintainable, and liberty is reserved to the petitioners to file a civil revision petition in accordance with law.
Thank you.
Office objection along with counsel submission. What is this annexure C series to be made? What is annexure C series? You refer to some C series. You have mentioned something as annexure C series. I clearly begin case in. What is the case? What? Are you ready or not? You're ready. Then why are you starting off so slow? Starting problem. What is the suit for? Suit is for mandatory injunction. What is the suit property? Wait, so what is your case on merits? Please come on merits. Why was the trial? Why did the trial court grant injunction? Why did the appellate court reverse it? Please come to paragraph number 20, page 27. Why does the appellate court reverse it? What is the width of the passage according to you?
Page number 16, mechanism. Page number 16. In order.
On what basis you are saying it is filed up? Yes.
It is not in discussion that the defendants are obtained data from the concerned authorities in local concern of they are also considered reasons and now they are trying to construct audit below this expected. According to the metric, the legislature is constructed which is common factor. This question about the training number doesn't mean that alleged package. And depending on the law,
so the staircase must be outside your house. The staircase must be outside your house. So why do you need a toilet to be below the staircase? Jaga is not
it is not in violation of the plan or
don't construct, mister. I thought it's a staircase. Maintain status quo.
These are staircase I don't. It is as per the plan I have constructed. It is not beyond the home.
The construction of the toilet can wait. It can wait. There are no toilets inside your house. Please put it in writing. Put it in writing that there are no toilets inside the house. Well, those what? Please show.
Holding the license as a tender point, the purpose of the documents are also produced by the issue with the review of where the rules mentioned at least the house of tender for rest of the north and south of the making does not produce documents with time in the region of the so I part of the report the at the 20 for mandate there it is very clear that the defendant has already completed RCC received the law and also stated for reasons of property. Now the executive the under this case. According to the plaintiff, the defendant constructed building by making improvement upon the common practice. very pretending that you get to compare the common price and then they can offer to the not like but it is not really based on the very good that we do not look at that. The very good that the difference of also we see the rules and regulations prescribed in the content. On the very good point to consider that the basis on limitation of variations of currency conditions. And the right to calculate we cannot decide that
What is there to show? What is a partition? Where is a partition deed?
the partition deed has not been produced before the court.
Okay, you must give a copy. Yes, Mister. Have you read the partition deed? So, have you read the partition deed? You not read. So what is this you are arguing? Huh? Well, honestly, why did you file the petition even without reading the papers, Mister? Mister, you are an advocate. So you are bound to look into the papers before filing your petition. Should you not see the partition deed to find out what is the width of the passage as per the document? Huh? So if it's a partition between two brothers, and one brother takes one property, the other brother takes another property, the area lying within is deemed to be a common passage. So don't put up further construction. Yeah, the partition deed government. Learn counsel for the petitioner and the respondent. Yes.
The documents which are available on record, the plaintiff claiming that this property is a common asset. And the other is the different containing the private property was the mutual side of the which exclusively belongs to them. The document produced by both the parties, private that they are claiming in respect of scheduled property. The elements are also disputed with the data of the property. There is serious dispute with respect to the common asset and the use. There are discrepancies in the both the job and the plaintiff in the main table and the documents available on the file.
So
In these both documents, there is discrepancies.
what discrepancy?
We are not.
Please produce the document. Yes.
Even though you are stating that it's.
You also not produce a partition.
I am not producing, sir. So I have produced the revenue documents which are clearly stated that the.
Why should we look at the revenue documents with this? Sir, parties are brothers. You have partitioned the property. Please produce a partition. Don't produce a revenue document. Revenue documents is of no use. Don't construct. Learn counsel for the petitioner. Counsel for the petitioner and the respondents each time to produce the partition deed under which the petitioner as well as the respondent claim title. In view of the same, until the next date of hearing, both the parties are directed to maintain status quo in respect of any construction, in respect of the scheduled property. Yes. Come to the court prepared. 27th October. It's on 27th October. For rejectment. At what stage?
These are the 3 years marked versus documents. Within the property development.
At what stage did you file the application?
The state of arguments. After commission of my there is very bad. Online I get an application. Confront my documents is P6 to P8.
It says P6 to P8.
P6 to P8.
What are those documents?
It's a rental agreement which have been executed on 5/1/2021.
Is that your defense?
Yes, sir.
Where have you said in your statement? Where have you stated in the statement?
In the petition act wherein based on the property schedule East West 35 and also and also the boundaries which have been stated at page in my written statement at page 27 I instituted it at page 2 here. Page 27
No, you said you wanted to confront exhibit D6 to D8.
Yes, sir. D7 and D8 are the documents which are obtained from the application which show the measurement is according to the stuff
Why should that be confronted?
Furthermore, in my
So this is a document obtained from proper custody.
yes, sir.
So why you want to confront?
There is a dispute with respect to
Why should you confront?
that D6 are executed on
5-1?
5/1/2021.
Where have you mentioned that in your statement? Written statement ಅಲ್ಲಿ ಎಲ್ಲಿ refer ಮಾಡಿ? 27. ಇಲ್ಲಿ refer ಮಾಡಿದ್ರೆ ತೋರ್ಸಿ.
Page 27, 2A, madam. Bottommost.
27. Both.
We submitted that with respect that this event is not in personal defense described by the client. Both the client and notice are issued by the describes the office of the scheduled property. Defendant is in the possession of the property with notice mentioned here that towards least these premises of also for thus if defendant is not in possession of the food property described by the client, the property which defendant is in possession and payment has not been sought for eviction.
ಎಲ್ಲಿ ಹೇಳಿದ್ರ 5/1/21 ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಬಗ್ಗೆ? ಅದನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
This agreement has been executed, but defendant has already not conformed to execute this agreement here. Page of 38 of that particular agreement has page 4 and page on 24/20, where in the course of the wherein the matter was settled for settlement. DWS3 number 3 has been examined and we have marked the document.
Check of 4 lakhs is encashed. ಎಲ್ಲಿ ಹೇಳಿದ್ರು? ಆಯ್ತು, ಇವಾಗ ಎಲ್ಲರೂ ಹೇಳಿದ್ರು ಇನ್ಕೇಶ್ ಆಗಿದೆ ಅಂತ. Please take out notice. Please take out notice. ಎಲ್ಲಿ ಹೇಳಿದ್ರು? 110. You immediately serve ಮಾಡ್ಕೊ ಬನ್ನಿ. To list it on 29th. She noticed in addition, learned counsel for the petitioner is granted to serve Learned counsel who represented the respondent before the trial court. It's on 29 September. Yes. Non-compliance of office objections. In the meanwhile, it will 27. In the meanwhile, office objections will be complete. 28. What is the order challenge? Is there an appeal provided? Is there an appeal provided? Sir, we have written in capital letters. It is printed in the cause list in capital letters. Maintainability of the writ petition in view of Order 43 Rule 1R. Have you taken the trouble of reading what this Order 43 Rule 1R is? Have you taken the trouble? Pass over. What is the suit for? Who are you? Notice in addition learned counsel for the petitioner granted to serve the learned counsel for the interim stay of the interim order till the next date of hearing list on acceptance of postal list for having sent copies. Mr. V. Shivakumar.
Mother and sister against father has taken the property to me and registered. Now, I question that we ask. Now, 2 portions of general property occupied by plaintiffs as well as the independent residents. There are about 4 or 5 vacant tenants. Father to not yet, but the bank has no issue notice that there is PG action and other using. To make accusation with the system get right. Using the bad language, that's not all the tenants to get. Other tenants to do this my interest. Therefore, I filed an application to say, permit me to inject the tenant. And I say, pay the GMIs. Here is the GMIs demand after. Next day, permitted rejects my application.
Please arrange.
Similar application is not filed by my plaintiff mother. But in my permission is granted to her. She is being placed on a pedestal in an application filed by her. She was responsible for vacating all the tenants. Only the from the EMI. People who solve by water charges. And I is the party. Tenant will be small. I mean that I have. Elevated agrees that there is Indian need for either interest, receive it and pay it towards the other. The eliminated on my application. By rejecting my prayer, and submits the mother to reject the parents. Now, India has married the department.
What is the total amount due?
EMI is worth their salary.
What is the total amount?
Worth their salary. And the open something, you don't ask for your project. Saying with the A to the code language against me.
How are you bothered? Let the premises be rented out. Let the rent go to the bank. ನೀವು ಮಾಡಿದೆ ಅವ್ರು ಮಾಡಿ ಎಲ್ಲ ಒಂದೇ ತಾನೆ.
And therefore I made the application. That if she have honestly filed the application, permit me.
Who is the owner of this? Who is the owner of this property?
Owner as of the registered others property. It's gifted to me. They are under a register. Therefore, I am the owner. There are more challenges that you take. But as things stand today, by virtue of I am the owner. And I have to pay the EMI so that as the tenant was there. Because the people have to pay that.
Implement the, please implement the bank. Please implement the bank in this case. Let us. The counsel for the petitioner is directed to implement. ಯಾವ bank ಅದು? National Cooperative Bank. You got to implement the bank which had financed a loan on the security of the suit real property. This time, when do you want it? Really, please implement the bank. Please implement the bank, sir. We do not know whether the mother and son are now siding to defraud the bank. You might be the owner. You and your son are now colluding to defraud the bank. You do not know. Better please implement the bank.
In fact, in my application, I given a EMI for 5 years.
Okay, implement my bank.
Police station
Just after the same is done. Yes, next. No. So, sir, the bank implement money. Bank and notice management we can consider.
Serial number 31, I appear for the petition. The office objection is that Order 7, Rule 11 application was rejected by the trial court. Section 115, my lord, that would have been CRP would have been more appropriate, my lord. But my submission, there is no prohibition, my lord. It may kindly be considered, my lord. There is no, but on merits there is nothing, my lord.
Merits melenilva.
Application, no grounds are made out to reject the application. Order seems to be. Therefore, if the office objection
The petitioner has challenged an order passed by the trial court rejecting an application under Order 7, Rule 11 of the Code of Civil Procedure. The office has raised an objection regarding maintainability of the petition. Notwithstanding the question regarding maintainability, notwithstanding, keeping open the question regarding maintainability. ಇದನ್ನ CRP ನ ಹಾಕೊಳ್ತೀವಿ. Order 7, Rule 11 of the Code of Civil Procedure. The office has raised an objection regarding maintainability of the requisition in view of an alternate remedy provided under Section 115 of the CPC. Stop.
Under the
Is not in dispute that the order impugned is revisable under 115 and 4.
not another. My submission.
Sorry, and therefore the requisition is not maintainable and the same is dismissed.
With the liberty to file the CRP.
Dismissed. It is however open for the petitioner to file a civil revision petition. Stop. The office is directed to return the certified copy of the issued order to the learned counsel for the petitioner after receiving the photograph. Yes.
Oh, very good. Okay.
Issue notice on IA 1 of 22. Notice on IA 1 of 22. Pushpa Hasa. Who has to start? It's all right. You please come on merits. Come on merits. Vacating go IA petition ella ondene. Please argue on merit. Pass it on. Pass. But these documents placed before the trial court. What is what is
because schedule of the agreement with the like there was an amendment, even after the amendment was not corrected, decrease in the cost of the given property not adjourned to the property. And also when it was degree in respect of relation to property, there was so many discrepancies in law. Therefore, I wanted inquiry and then because the trial court
you contested the suit on merits.
Contested the suit, but what happened was the last document page number 18. Page number 18. But subsequent to the agreement of this document was exported much later about 1887 and based on clause number 9. So, This was this very interesting because they would not produce the original of that. However, on the other side, they said that they don't have a document. No, I could not get my hands on it.
Let us see the application which you have filed. Suit is for what? Suit is for?
The specific purpose to directly go to execute the same date. And the first part, no possession is tempered. Possession was not granted by the court. Pursuant to the agreement of self possession was not.
So what is the issue in this case? Is it regarding possession or is it regarding boundaries? This is a question.
All those things are questioned. One, executability because if possession is not delivered as a agreement, if when we not only seeking execution, the direction of the we should also seek possession.
We will seek possession after the decree.
That is also not done.
Execution ಕೇಳಿಲ್ವಾ?
ಹೇಳಿಲ್ಲ.
ಕೇಳ್ತಾರ ಆಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕ್ಲೋಸ್ ಆಗಿಲ್ವಲ್ಲ ಇನ್ನ.
Execution cannot executing part will only execute it is not guaranteed. How can you execute
Possession can be delivered. Possession can be delivered as part of the decree. There is a judgment of the 1984 ಯಾವುದು? Possession can be either recovered through filing a separate suit or in the execution itself.
What the court says, what the executing court says is, we will even without the decree, apart from executing the same way, we will deliver possession, not restricting the fact that possession is not delivered to be prospective purchaser in Muslims. But you recovered the possession from him. He was a license. After that, there was a foreign license. After the vendor is one possession again. Property, the site belongs to him. Over the site, the construction is very modern construction was being done. On 23rd of May 1995, an agreement was executed only by the present petitioner's possession area. He came out so much. After that, in the agreement, there was no possession of delivery. Subsequently, on the same day, two more documents were taken. One is done as Karnataka agreement. Next thing is GPA. We were of those two documents, they were wanting as a license. They were not delivered to possession as a prospective purchaser.
Yes, a decree. Mr. Are you trying to confuse me or? There is a decree.
Page number.
There is a judgment. Have you produced this agreement before the trial court? It is produced, marked, and the court has still directed you to execute the sale deed. Notwithstanding these documents that you intend to now place on record, the court has directed you to execute the sale deed, correct? Now, an appeal is filed in RA 11 of 11. Appeal is also dismissed. Dismissed. So therefore, your contention that there was an agreement, that he was a licensee, all those things are considered and rejected. No, that is your problem. That is your mistake.
Before reading the degree, as the Lord has said, when we come to page number 21, this is one of the
Yes.
This is the that in the agreement dated 23 October 1995, when you say the Vision 23 says, and the relative came to know about the mistake only things open sectors of the art and research pertains to the property. Actual survey number of the property is 285 bar 2, sense. So after that, an amendment was carried out. Even after the amendment, they don't amend the extent of the land. Boundaries are that much. And the very 85 bar 2, not 285 bar 2 commands, and it is in and there is no boundaries also. And next, as I said, I come to the degree. I get this separation of 25. 285 bar 2, the description of the issue property and above referred to. Immovable property situated source of say 285 bar 2 to see equal to the agreement of the property is not equal to 285 bar 2. So he is of the consent not basically. So come to the next document that creation of the and waiting there, there is number 50, needed serial number 4. That the dependent is some calculation with others. Here also, property was as and there were no boundaries. In the execution petition, number 31. Then mentioned, but in the rare properties, or rare properties, the mode in which the access to the court is required. This was based on the following related by property in favor of the decree holder, as for the decree holder the demand of the state of India, now, second, he admits his application by was disclosed from the beginning. Then it is like he has was sent back for reason. But the second appeal is right. I don't want to reject that. But I want to first of all report here. That is other reason they have mentioned that they wish to reply so subsequently they are not in compliance and then by the execution petition, he was running this way. Not deposited.
You are entitled to seek for rescission. File an application for.
First, you have to complete it for the records implemented.
Where is the decree in RSA? Let us see what happened. Let us see your application, Mr. 47. Let us see what is that you have said. ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅದಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದ್ದೀರಾ?
This article is again number 2 is passed on 9980. Which is now having to be
Yes.
Now we are
Please come to the content.
number 27. This is passed on 1990. 3 years thereafter, in view of the dismissing of again number 2, again number 3 does not survive or considered. This is what the report does. It doesn't contain my application. Because I have dismissed item number 2, I also dismissed item
Where are reading? Where are reading? Based on
item number 57, 39, 2019, article. In the allowed detected rule, allowed detected.
9/9/2019.
There is the order chapter in this is 1980. In that, come to page number 57, last one, again, 3919. In your.
I don't see. I don't see anything. Page number 57. I don't see 39/19. Page number 57 starts with paragraph number 15. Yet another ground.
No, then there is some after the entire order, next page of the order.
Call on for steps 39/19.
I 3919. I'm reading down. In your dismissing IA number 2, IA number 3 does not recognize.
What is IA number 3?
Maintainability.
Of what?
Maintainability of the execution written on the road first, not completed, first applied for order, not deposited. Just one thing. Second thing is, now the starts with the agreement of sale, one property uses, then schedule is divided.
Grounds which you could have urged in RSA up to RSA. That is already considered rejected. So the court has accepted that the property that was shown in the agreement was wrong. And the court has accepted the contention of the plaintiff that it is 285/C2. So how can you now again reach the point in execution? What different property? Court has accepted that. The court has accepted 285/C2.
The first article only on the merits
Sir, you had a ground to argue. You did not argue. Even if you argued, the court has rejected it. How can you again renew that ground in execution? Astelva?
The document, the last argument, it's not considered.
That is your mistake. That is your file a review petition if you want. File a review petition. If you say that it's not considered, it's not produced, file a review petition. But that will not be a ground for you to re-urge that ground in execution. Ground which is already considered in the civil case, confirmed by the appellate court and the second appellate court, it cannot be permitted to be urged again in execution.
Now, the first argument is answered. Here, the advantage of the fact that what I am now by the allowed the application statement was not accepted by the person. Here, the other contention is that they run only as a licensee, subsequently they is vacant and they will hand over the possession. Now, when you see another document is taken, she is a permanent resident of office. Now somebody else is running the order understanding in the license which he took over from the wife of the petitioner. And he is running the
These are all grounds that you could have urged in the civil suit. What is this? Pushpa, not a young lawyer. I did not tell you. Whatever you have urged in the civil court, you can't urge it in execution. What small? It's not a small inquiry, no inquiry. The inquiry is already done at one stage. OS stage of the inquiry is done. You had an opportunity to seek for inquiry in the appellate court that you did not avail. In RSA, you did not take any steps. You did not contend that this agreement is not considered. You did not do it. You waited for the court to decide. And now you come before the executive and say, no, that ground was not urged in the original suit. How is it possible? Paragraph number 8. Paragraph number 8 is page number 9. Petitioner submits that therefore.
court for that. So I see being not a party now. Why not the petition has quite a four years for 3 days? On the side of the civil, in the execution not pending
And they-
the property which belongs to her, which she could not, which her husband not proceed.
That will protect. That will protect you. Sir,
She has permitted.
these are all these grounds were available for you to urge in OS, the original suit. Did you urge it? If you had urged it, it is rejected. And cleverly you have not produced that decree, judgment. You not produce a judgment of the trial court. You not produce a judgment of the first appellate court. You not produce a judgment of the second appellate court. In the writ petition, where have you produced? You only produced the decree, not the judgment. So therefore, if all these contentions have been considered in the original suit, if it is considered, how can you argue now? If it is not considered, how can you now request the executing court to consider it now? You had an option to urge that ground. If you have urged it, you can't urge it in execution. If you have not urged it, you can't raise it in execution because you have lost it. Again, don't argue the same thing. Purple. Is anything else? Yes. That this ground was considered. I thought, what about this exhibit P2, P3, what are these things? That is also considered. Yes. So if it is considered, be ready to pay cost. You should be ready to pay cost. Please read from where exactly this contention was urged and considered. Yes, please read. Yes, Mr. It's all considered 2011-97. Full. Impose heavy cost. Cost will be imposed. Then second start was the judgment data in EP number 78 of 2018 on the file of the principal senior civil judge in Dame has filed this petition challenging the correctness of the order dated 13/9/2019. By which his application bracket IA number 2 bracket close under section 47 of CPC was rejected. Next para. The suit in OS number 160/2000 was filed for specific performance of an agreement of sale 23/9/23/5, which was in respect of the land bearing survey number 286 of village of Cherkadi village, Udupi Taluk, measuring 23 cents. To stop. Later, the plaintiff realized that the suit property was wrongly described as survey number 286/2B instead of survey number 285/2. Hence, the suit was filed in respect of survey number 285/2 of Cherkadi village, Udupi Taluk. Was the agreement amended?
Was
the agreement amended? Stop. You have suffered all these things. You suffered. Stop. The suit after contest was decreed in terms of the judgment and decree dated 30th November 2010. Stop. An appeal was preferred by the judgment debtor / defendant in RA 11/2011, which too was dismissed on 27/4/2018, and RSA hakidira 1377 of 2018 filed was also dismissed. So, stop. Thereafter, the decree holder, filed execution petition 78 of 2018, seeking for execution of a sale deed on behalf of the judgment debtor through the process of the court. Stop. During the pendency of the said execution proceeding, the judgment debtor filed an application under section 47, section 151 of CPC, bracket IA number 2, contending that the execution petition is not maintainable and that it is obtained by fraud, misrepresentation, coercion. It is also contended that the execution petition was in respect of a different property than was shown in the agreement of sale. It is also contended that possession of the suit property was not delivered under the agreement, and therefore, an execution petition cannot be filed to seek to recover the possession of the property. It is also claimed that the wife of the judgment debtor had filed OS number 324 of 2019 to safeguard her rights over the suit shell property. It is also contended that there is no clarity regarding the property that had to be conveyed to the decree holder. Full stop. This application was opposed by the decree holder, and the executing court, after considering the contentions urged by both the parties, rejected the same in terms of the order dated 9/9/2019. Being agreed by the said order, the present petition is filed. Next, the learned counsel for the petitioner reiterated the contentions urged before the executive court and contended that the executing court ought to have conducted an inquiry to find out whether the decree was obtained fraudulently and whether it is enforceable or not. Stop. He submitted that since the agreement is not amended, the court could not have granted a decree in respect of a property which was different from the one mentioned in the agreement of sale. Stop. He also contended that the possession of the property was not delivered under the agreement of sale, and the decree also did not indicate that the possession of the property had to be delivered, and therefore, the execution petition filed was not maintainable in law. Next paragraph. Learned counsel for the respondent on the other hand submitted that the contentions urged by the petitioner were all considered by the trial court in OS number so and so, as well as in the first appeal and the second appeal, and therefore the petitioner cannot urge the very same contention in the execution proceeding. Next, I have considered the submissions made by the learned counsel for the parties. The judgment and decree passed by the trial court in OS number so and so, as well as the judgment and decree passed in RA, clearly indicate the contentions urged by the petitioner were considered and negative by the trial court as well as the first appellate court. Full stop. The petitioner cannot now assert the same contentions in the execution petition and obstruct the execution of the decree. That way of the matter, the trial court was the executing court was justified in rejecting the application, and this court does not consider it appropriate to upset the finding of the trial court. So that way of the matter, this petition lacks merit. To stop. Having regard to the fact that the petitioner, even after failing in 3 attempts, has renewed the very same contention before the executing court and has thereby obstructed the flow of justice. This court therefore considers it appropriate to impose exemplary cost of rupees 50,000 payable by the petitioner to the respondent on the next date of hearing before the executing court, failing which, the executing court is at liberty to recover the same in the manner known to law. Sir, ಉಪ್ಪಿನಲ್ಲಿ ನೀರು ಕುಡಿ. ಎಷ್ಟು ಹೇಳಿ ಅಷ್ಟು ಬೇಡ ಅಂದ್ರೆ ಎಷ್ಟು ಹೇಳಿ ನೀವೇ ಹೇಳಿ. ಆಯ್ತು 50% ಡಿಸ್ಕೌಂಟ್ 25,000 ಮಾಡಿ. Sir, this is an absolutely frivolous petition. The frivolous petition. 25,000 number. Next.
I appear for the petitioner.
I can increase it to 50,000 if you want. If you don't leave it, I'll increase it to 50. You should not to tell the clients ಇದು ಆಗಲ್ಲಪ್ಪ ಹೈಕೋರ್ಟ್ ಬರ್ಬೇಡ ಅಂತ ಹೇಳ್ಬೋದು. Lawyers also owe a duty. ಇದ್ರೆ ಕೇಸ್ ಇದ್ರೆ ಹಾಕಿ ಬೇಡ ಅಂತ ಹೇಳೋದಿಲ್ಲ. But when there is a misuse, clear misuse of the process, correct? If you continue to argue, I'll increase it to 50,000. But still continue to argue. Next.
I appear for the petitioner, please, my lord.
Yes.
I appear for the petitioner. The petitioner has filed OS 26,687 of 2014 before the district court. The respondent on appearance filed an application under Section 8 of the Arbitration Act, which application was allowed. This is suit for rupees 1,28,92,807. Then I preferred a CRP. Then subsequently the CRP was withdrawn as it is not maintainable, and I have filed this.
Why do you say that Section 8 is not applicable?
because there's the suit claim involves 8 contracts, 8 bills. It's only in one case there was a arbitration agreement which they have produced.
Was it different contracts or bills in the same contract?
Different contracts, please.
Different contracts.
Yes, my lord.
And you filed a composite suit.
Yes, my lord.
That is a mistake that you did.
No, the claim parties are the same. It was for different projects of the defendant.
Then you should have separately filed separate suits, isn't it?
We have filed a complaint suit because of the defendant is the same, and there is a one comprehensive suit was filed.
You have taken permission of the court to deduct that portion of the claim which is not the subject matter of, which is the subject matter of an arbitration agreement. So if you club everything,
Yes.
the court has no option but to reject the entire thing or return
No,
the
my
entire.
lord. No, my lord. It is not that. If there are different this thing, there are many decisions also on that point. That's why I have filed an early hearing application. It's a 2014 matter. I will convince the court, please.
So IA 1 of 2022 is filed for early hearing of the petition. Since the petition is not admitted, IA 1 of 2022 is rejected. This is the petition for preliminary hearing in B group as per seniority. Next. The request of the land council for the petition this on Thursday. Yes. Give permission at the request of the land council for response 192 list on. Yes, Mr. Bas. Shankar Reddy. Basaraj Patil. Pre-trial amendment. Is it a pre-trial amendment? Who are you, a purchaser? But which you are agreeing? We'll hear it.
Not in this case, in serial number 37, my lord.
Yes, sir.
Serial number 37, I appear for my lord Raghavendra Pattiman.
That requires hearing.
Lord,
We have to hear the matter on merits because there seems to be a lot of other proceedings.
yes, I had taken a preliminary objection that the GPA was not in existence at all, it was cancelled. The false affidavit was filed. My lord, sir, please to ask it.
Anyway, we can't dispose it of at the order stage. We'll consider it later. IA 1 of 22 is filed for vacating the interim order dated 8/3/2022. Having regard to the fact that hearing IA 1 of 22 would invariably result in hearing the entire expedition, IA 1 of 22 is disposed of. This petition for preliminary hearing in B group as per seniority.
Can the IA be taken up along with that instead of disposing it off?
B group will let it come. Because if it's in IA for vacating stay, then it will come up for orders again and again. Let it come for, yes. Interim order, what is the nature of interim order? If you are in possession, you continue.
If the next date and that.
The interim order granted earlier. Order of status quo granted earlier is extended in the next date of. Huh? Seniority ಪ್ರಕಾರ ಬರುತ್ತೆ yes. Mr. Sharath. Yes, Mr. Huh? ಆಯ್ತು ಹೇಳಿಪ್ಪ ರೆಂಟ್ ಯಾವ ಕೊಡ್ತೀರಿ ಹೇಳಿ. Won't do 40 lakhs. ನಾಳೆ ಅಲ್ಲ ಇವತ್ತು ಬಂದಿರೋದಕ್ಕೆ ಹೇಳಿ ಎಷ್ಟು ಕಟ್ತೀರ ದುಡ್ಡು ಡೆಪಾಸಿಟ್ ಮಾಡಿ. What is played fraud on the court? What do you mean by that? Playing fraud on the court? You had an option to bring it to the notice of the court. Sir. Will you please sit down? Kutul. But are you paying rent to anybody? Have you paid the rent to anybody? So therefore, you better deposit. What is the decree, Mr. 2,70,000? How are you claiming? There should be an inquiry. Is there a claim for payment of damages? What does the decree say? Please read the decree. Sir, you're done. Sit down. Yes, what does the decree say? I know the decree and page number 33. I to ask you to sit again. 2 ಸತಿ ಹೇಳ್ಬೇಕಾ? 33. No. ಇಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ? ಪೇಜ್ 33 ಬನ್ನಿ, ಡಿಕ್ರಿ ಬನ್ನಿ. ಆಯ್ತು ಓದಿ. ಇಲ್ಲಿದೆ further damages. Therefore, you have sold the property on 3/8/2018. We are not on that. The decree does not say that you are entering for the mean profits. It may be a wrong decree. There might be a mistake in the decree. You should get it corrected. Without getting the decree corrected, without there being quantification as to what is the mean profits to be paid, how can you claim? When will you deposit this? 2,70,000. When will you deposit? It's the first deposit, 2,70,000. What does the decree say? Please read the decree. Read further. Read further. What does it mean? So you should pay the arrears of rent. Pay that arrears of rent. 2,70,000. When will you pay? I hope you understand English. What does it mean? Once you pay the arrears of rent, then the plaintiff will have to refund the advance amount. Correct? Pay the arrears of rent first. You do not know what kind of damage you must have done to the premises. When will you pay? Pay the arrears of rent. Therefore, the counsel for the petitioner is directed to pay the arrears of rent of rupees 2,70,000 as per the judgment and decree dated 8/10/2021 within a period of 1 week before the executing court. Stop. If he said rent is not deposited, the interim order of status, interim order of stay granted by this court on April 2022 shall stand automatically dissolved. Pay the arrears of rent. What's the arrears totally? Let him pay the arrears. What's your name? Mr. Sridhar Chakravarti accepts notice for the respondent. Respondents. Disposed of matter. When extension of time by rent ಎಲ್ಲ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? Rent ಎಲ್ಲ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? Yes.
They filed this memo before the trial court, saying that we are not liable to pay any amount. These kind of the order of the trial court as well as the Reciprocal. And they are very negative. I should deposit 8 lakhs.
Where is the order passed by this court? The time for complaints of the impugned order passed to the trial court is extended by 1 month from today. So, 23rd September. You directed to deposit. How much have you deposited? How much have you deposited till date? Not a single pipe. No, don't. So the balance is zero with you.
I don't know. I have this number. I am not.
You keep this party present with him. If he has filed this memo before the court, keep this person present. We initiate action. The relevant counsel for the respondent has placed on record a memo filed in OS number 253232 of 2015, which is in absolute violation of the order passed in OS number 25232 of 2015, which was confirmed by this court in WP number 16618 of 2022. So in view of the above, the learned counsel for the petitioner is directed to keep the petitioner present before this court on Thursday. Failing which Thursday. If you deposit with accounts. So that is why I asked you whether the amount is zero with lying with you.
I wanted to know examine the same how about the whether we can not have party versus I file applications to apply the same person as the so that it finds him around that application is rejected on the ground. That I filed already commissioner's report and get an exam of this not necessarily exam. The second opinion is
At what stage is application? This is Jagadish. There is no representation for the respondent. Listed for preliminary hearing with IA 1 of 2019 shall be considered along with the main expedition. Stay granted earlier. Is extended till the next day. Under further orders and stay granted. This is order dated 4/6/21. Interim order granted earlier extended until further order. Yes, Sumati. There is no representation for the petitioner list on. Password. Clear option. At the same rate, 8,000. What is the third one? What is the third option? So only two offers. ಆಯ್ತು ಬಿಡಿ ಅವರು ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ಗೆ ಕೊಟ್ಬಿಡಿ ಇವ್ರಿಗೇನೆ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ ಸೇಮ್ ಟರ್ಮ್ಸ್. ಎಂಟಾಗ್ಲಿ ಎಂಬತ್ತಾಗ್ಲಿ, ವಾಟ್ ಎವರ್ ಟರ್ಮ್ಸ್ that you have entered into with your developer, same terms let it be given to him. ಎಲ್ಲಿಯ ಪ್ರಾಪರ್ಟಿ ಕಲ್ಲೂರು ಎಲ್ಲಿಯ ಪ್ರಾಪರ್ಟಿ ಇದು? ಹಾ take the same, you offer it to your joint development. Yes. ಆಯ್ತು 7 ಗುಂಟೆ 7,000 ಅಡಿ ಆಯ್ತು, 7,700 ಅಡಿ. ವಾಟ್ ಮೋರ್ ಯು? Correct, you are getting the largest place. Developer, he will definitely develop. Developer ಕೊಟ್ಟಿದ್ದಾರೆ, you have come to a settlement, he is willing to give you 3.5. ಇಬ್ಬರು ಅವ್ರು ಕೊಟ್ಬಿಡ್ಲಿ ಅವರು. When will you? And counsel for the respondent seeks time installment Thursday. Hmm. 44. This H.N. Narendra.
Miller. 44. I am the petitioner.
H.N. Narendra ಅಂತ ಇದೆಯಲ್ಲ, ಉಮೇಶ್. You are at 46, Mr.
Sorry. Excuse.
ಹೇಳಿ ಏನಾಗಬೇಕು? Joint counsel for the respondent number 2 is placed on record a report of a local inspection conducted pursuant to the order of this court dated 8th August 2022. Copy ಕೊಟ್ಟಿದ್ದೀರಾ? The joint counsel for the petitioner seeks time to verify the report. List on date put. Let it come, madam. ಏನ ರಿಪೋರ್ಟ್ ಏನ್ ಹೇಳುತ್ತೆ? Pass over, let us see, pass over. Mr. Prakash. Mr. S.V. Prakash.
I am for the petitioner, my lord.
46.
My lord.
Pass over.
I am the petitioner, my lord. It is against the order of the trial court passed regarding the payment of stamp duty and penalty, my lord.
What is the document?
It is a sale agreement, my lord.
Sale agreement.
Sale agreement. But
What is the
prior to passing this impugned order, my lord, the matter was directed to the district registrar. I point out the order dated 7/11/19, lord. Ink page number 41. Operating portion, ma'am. Office is directed to send the copy of the said agreement of sale dated 13/1/2000 to the district registrar Shimoga to calculate the duty and penalty on the said agreement. The district registrar Shimoga is directed to calculate the duty and penalty on the said agreement as it is an unregistered and unstamped agreement. When once that kind of order has been passed, now this honorable court, trial court ordered on 18/6/22, my lord. Ink page number 60. Its typed copy is on 62, my lord. My submission is that, my lord, once the document was referred to the district registrar, it is the domain of the district registrar. Hence, the impugned order may kindly be questioned. I will approach the district registrar regarding
issue notice? In addition, the Learned Counsel for the petition is directed to serve the HCGP. Stop. In the next date of hearing, the order dated 18/6/2022 passed to the trial court is paid. All men. Not 230.
Court officer, serial number 56 adjourn ಆಗಿದ್ಯಾ? Court officer. Court officer, serial number 56 adjourn ಆಗಿದ್ಯಾ?
Huh? List number 2. Seal number 2. Counsel for the petitioner submits. Counsel for the petitioner submits that the regular appeal from which the present petition arises was itself disposed of. Cost is ₹500. He undertakes to pay the cost of ₹500 during the course of the day. In view of the above, subject to the petitioner depositing the sum of ₹500 as ordered on 31/3/2022, the petition is disposed of as having become infructuous. With ಕಟ್ಬಿಡಿ ₹500. $1.1. ಯಾವುದು ನೋಡಿ ಇಂಟ್ರಿ ಮಾಡಲ್ ಎಕ್ಸ್ಟೆಂಡ್ ಹಾ 1.1. What about 1? ಎರಡೂನಾ? See number 1 now. Current counsel for the petitioner submits that in view of the withdrawal of the suit, voice number so and so, the suit does not survive for consideration. In view of the memo as well as the submission, the petition is dismissed as infructuous. What is the order passed? Now, what is the order passed in this situation? You raised it as a preliminary issue. Current counsel for the petitioner submits that in view of the judgment of the full bench of this court in ILR 2018 Karnataka 5095, the issue regarding court fees cannot be treated as a preliminary issue, and therefore this petition does not survive for consideration. In view of the aforesaid, the petition is dismissed. It is open for the petitioner to raise the question regarding court fees in this suit. Yes. 71. ಅದೇ ಇದು ಥಿಯೇಟರ್ ಪೂರ್ವಶಿ ಥಿಯೇಟರ್. Please wait. Correct. You paid? Bakshis Joyce. There is no representation for the petition. The last chance 2 weeks time is granted to do the needful, failing which the petition against the unserved respondent shall stand dismissed. Counsel for the petitioner submits that the counsel for the petitioner seeks leave of the court to withdraw the petition with liberty to file an appeal as provided in the order 43 rule 1R of CPC. In view of the submission, petition is dismissed as not maintainable. Liberty is reserved to the petitioner to file an appeal as provided in order 43 rule 1R of CPC. Office is directed to return the certified copy of the impugned order after obtaining a photocopy of this. 42.
accrued you have to do that. How do various different but what are the standing for the that is what.
But some lawyer is representing Mr. BGS. No.
So ಹಾಗಾಗಿ ಇಲ್ಲಿ ಎಫ್ಟಿನಲ್ಲಿ make sense that the very application because we want to allot maximum for so allotted is himself for this one. For which my application
So when did you purchase? After this? During the pendency of the suit.
I was
1991.
fully certificate lecture I have to do
2009 ಅಂತ ಇದೆ.
2009 sir. Is it right? But I have to find out before. I say here case
This is a contested decree or what?
it is not contested, but as it is with the Collusion 5 on
ಆಯ್ತು ಕಾನೂನು ಪ್ರಕಾರ decree ಆಗಿದೆಯಾ? So therefore your right is only to seek for allotment.
Seeking allotment of the share in the rock of my independent.
ಏನಾಗಿದೆ?
Other than none objection and conditions they have turned out by passing the understanding that you have to sit for the second and technical working in different not which is at the technical 38 and 13 include us after report. He instantly has a picture of the name of the father of the response was Nagegoda and then after do the amendment his name is directed to Nagegoda. But why is open to the Lucy to criminality it makes it clear that the father was referred to as Nagegoda. If the response was not there, the father he has to find research
No, but what if, sir, what if the application for? ಅಲ್ಲಲ್ಲ ಇದು FDP ಡಿಸ್ಪೋಸ್ ಆಗೋಗಿದ್ಯಾ? Notice. For the petitioner, also represented the respondent to the trial court. So we find. Decree. Decree number also is state. However, all further proceedings shall continue. What is the report now? Against us, there are petitions against us.
That is what they have done.
Yes, is this acceptable to all of you? What about you? Will
Refresh, madam.
comply, both of you shall comply with this text. Will direct the executive engineer to verify whether the compliance is in accordance with the sketch. Yes. Full. The Belgian auditor, learned counsel for the respondent number. Learned counsel for the respondent number 2 has placed on record an affidavit of the executive engineer of the Mangalore City Corporation. Wherein he has suggested that the plaintiffs have to make that the plaintiffs have to make arrangements in their respective properties as shown in the sketch to ultimately connect their drain to the 15-meter drain to be formed by the defendant as shown in the sketch. We'll stop. Denoted comma close. He has also stated that the parties who are present accepted this suggestion and acknowledged their willingness by signing the spot masses prepared by me. Note comma close. Learned counsel for the petitioners as well as the learned counsel for the respondent number 1 has acknowledged that they would comply with the formation of a drain as shown in the sketch attached to the report of the assistant executive engineer. So, the executive engineer. Stop. So they also concede that after formation of the drains as suggested in the sketch, the executive engineer may be directed to inspect the property and ensure that the drains laid by the petitioners and the respondent number 1 shall match with the drains mentioned in the drains as shown in the sketch. Stop. In order to ensure compliance of this order, list on Yavatu. Really, Yavatu. List on 7th November. 7th November.
I think one part of the trade that they show is probably not on the profit of the defendant. Because that may fall under the municipal corporation scope. Short intent, they may have to take. Public
Yes, Mr. 7/11/2022. Stop. The petitioners as well as the respondent number 1 shall strictly comply to this while laying the stormwater drain. ಯಾವುದು ಮೇಲೆ ಜಯದೇವ್ ಪಕ್ಕ Jaydev.
Very short area right on top.
It is Jaydev property. Go. Correct.
So I think that comes within the scope of operation.
If there is already a drain, Prastapita Male Neeru Charangi.
Further from that, there is already a
ಪ್ರಸ್ತಾಪಿತ ಚಲನೆ ನೀವು ಮಾಡಬೇಕಲ್ಲ. Please wait. Mr. Bandari. ಅದು ರೋಡ್ ಅಡಿಲ್ ಬರ್ಬೇಕಲ್ಲ. You should form it. The respondent number 2 shall also form the stormwater drain as found in the sketch. Below the road, abutting the property of Mr. Jaydeva.
This property belongs to the.
Abutting the property belongs. No, there is a road, Allah. It's below the road. Abutting the property of Mr. Jaydev. Jaydev just made one portion. To whom does it belong? The property below the property of Mr. Jaydev. ತಪ್ಪ ಕೊಟ್ಟಿದ್ದೀರಾ ಸ್ಲಿಪ್ಸ್ ಅಂತ ಯಾವ್ದು ಬೇರೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ನಮಗೆ ನನಗೆ ಕೊಟ್ಟೋದು ಇದು. ಅಲ್ಲ ಇದು ನಿಮ್ಮ ಇಲ್ಲಿ ಹ್ಯಾಚ್ ಮಾಡಿದ್ರೆ ಹ್ಯಾಚ್ ಪೋರ್ಷನ್ ಪ್ರಸ್ತಾಪಿತ ಅಂತಿದೆ. ಕರೆಕ್ಟ್, ಪ್ರಸ್ತಾಪಿತ ಅಂತಿದೆಯಲ್ಲ. ಅದನ್ನ ಒಂದು ಕೆಲಸ ಮಾಡಿಬಿಟ್ಟು the Mangalore City Corporation shall form the stormwater drain shown as double prastavita male neeru charandi inverted comma close in this sketch. If not already done. ಮಾಡಿಲ್ಲದಿದ್ರೆ ಮಾಡಿ. ಮತ್ತೆ ಪ್ರಸ್ತಾವಿತ ಅಂತ ಯಾಕೆ ಹೇಳ್ತೀವಿ? List on 9th November 2022. $40, 45 same order. 45. ಒಂದರಲ್ಲಿ ಮಾತ್ರ ಹಾಕಿರೋದಾ? In view of the order passed WP number 14338/2022, no further orders need be passed in this petition. This town found the same day. Mr. Varadaraj Rangnath Havaldar. ಎಲೆಕ್ಷನ್ ಅಂತ ಮಾಡಿದ್ರೆ ಏನಾಯ್ತು? ಯಾವಾಗ ಹೇಳಿ? ಇವತ್ತು ಹೇಳಿ, ಯಾವತ್ತು ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳ್ಬಿಡಿ. ನಿಮ್ಮವ್ರು ಬಂದಿದಾರ? ಸ್ವಲ್ಪ ಕೇಳಿ. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಟ್ರಸ್ಟೀಸ್? ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? 11 ಜನ, 11 ಜನ ಟ್ರಸ್ಟೀಸ್. Yes. Yes.
They say that he is not repaired, 3 years are over. And the regulation they have given. Not comply with the regulation. No agenda is mentioned in the name of it. So what the trial court has been stating that there is regulations are always are not these things removed are not in the matter of trial. I'm not sure it is Let's do a relook into the matter. It has not done so. So, what you will kindly see. Let me do. Content could order. Can it come to trial? Petition for order.
No, a fresh managing committee is constituted already. Whether a fresh managing committee is constituted without elections, how can you do it? No, without his participation, he's still a trustee. Correct. He's still a trustee. So therefore, did you intimate him? Did you intimate him that the election will be held on such and such a date? If you are interested, you can file a nomination. Can model it. Yes. Are you interested to face the election?
No. Here,
When you face the election, will
When he executive was up to 5 years back, what was the reasons for them to remove him before that?
yes.
Now, I'm trying to read the order. The circular to order. I am coming to paragraph 29 order, page 54. The trial court do in prima facie case, the fact that the irreparable loss and balance this was reflected in the prayer of the second hearing that the public had wronged or having interest in the determined to be part of public the event has not for the granted. Therefore rejected the prayer not very but something not to be said that day. There is no mention that any order from the same Buddha reduce the public has. But this is a very private structure. The Kalyan Mandapa is there. The Reciprocal and the Government Council will do the so there is no allegation that any order to reduce the defendant. So, the Lordship will continue. Judgments continue. Any company has a date for the date to get here to the decision whether or not to grant it and it will not be taken has to be taken at a time. The decision the legal the any violation of such as these are expected on the required. Again, by way of and the stop injustice will be treated because that's uncertainty to be resolved. The object of interpretation is injury by violation of the right, for which it could not be adequately considered in language. Regarding the action, the facility was resolved. Need for such protection has however to be built against the corresponding entity of the defendant to be protected against injury. Resulting from having the prevented from exercising one legal right, for which it could not be adequately compensated. Both must pay one fee and another. Determine whether the balance of where the balance is. So, it's simple to is that what is the inconvenience of the the action of removing this petitioner from the the honorable one, not founded on the guidelines of the trust. And the resolution and the notices given by them are constantly the guidelines. Therefore, cannot be said that they would be English. In the petitioner who had the first was appointed in 2015 and was appointed in 2019. And in 2021, they said that his requirement did not require it. How could they decide that? on 11/8/21 has been not required by law. And the electrician government has written indicate any agenda. So under these circumstances, I have again what is the prima facie? It is not a prima facie done in that should subsidy 100% of 100% subsidy. Yes. So it is made of a prima facie matter. This is very protected.
Both of them will be the same. No, obviously. No, it will be the same, Mr. Grant of temporary injunction, grant of final relief. It will be the same.
The court says that the interim order cannot be.
Yes. Yes.
Alignment again is indicated the practice of granting interim orders, which particularly in the principle starting the was no better result than that the prima facie case that we made out. So we concerned about the balance of payments in the obligator and all the other.
Please tell us, is there any allegation of misappropriation existing?
There are reasons also where against the
ಅದು ಬಗ್ಗೆ ನಾವು ನೋಡಿ ಕೊಟ್ಟಿದ್ರೆ ನೋಟಿಸ್ ಅವರು ಜನ ಕೊಟ್ಟಿದ್ದೀರಾ?
act of petitioner itself amount to mail out violation of he has retained the government and having the date of the development. He is not able to do he has given adamant reply to the state notice. Thereafter they have after the second notice they have issued.
No, but then when you issue a notice calling for a meeting, should you not mention what is the purpose of the meeting? For what reason? Yeah, third notice you have mentioned. But for the first and second notice. You issue a notice asking him to conduct a meeting, call for a meeting. Should you not tell A, B, C, D reason? You want a meeting to be held, please convene a meeting at the Kodaka Barwa.
First and second notice, he has given adamant reply without conducting the restaurants have here mentioned that regarding.
I think by the third time, by the time the third notice was issued, was his term come to an end?
No, here the resolution against the bylaw matter has continued.
There is a resolution against the bylaw. What is? Please, tell us what is his appointment, whether his election as the president for the second term is not provided under the bylaw? Of course.
He has to be
Those, please, show it from the bylaws. Are eligible to be co-opted as board of trustees or the committee of trust again by the existing trustees. Please read. The board of trustees or the committee of trust, come to that page 80.
Ordinarily, it
Consist. Extendilva.
ordinarily consists of not less than
5.
5 and not more than even. The trustees may nominate
Co-opt to the board of trustees
if necessary
to make the total number 15. Next.
The board of trustees shall hold the office only for 3 years and
Liable for retirement for
retirement from the board of trustees committee of the trust. The trustees hold term of office.
Mr. I'll read, please listen to me at least. The trustees whose term of office expires after the expiry of 3 years are eligible to be co-opted as board of trustees or the committee of the trust, again by the existing trustees. The managing trustees may, if he or she so desire, resign his or her board of trusteeship even before the expiry of the term of his or her board of trusteeship. Subject to the provisions herein contained, the trustees shall vest in and be administered by a board of trustees consisting of one chairman, president, one chairman, vice chairman, vice president, one general secretary, one joint secretary, one treasurer, and the board of trustees or the committee of trustees. So after 3 years, there's no power to continue.
You can only go.
Not as a. Yes, sir.
Provided only for the level of city.
Yes, sir.
Below 4, page 86.
Page 86. Please wait, please wait.
Page 86.
Page number 86. What? Yes.
Provided that any such trustees will not maintain the expiry of the period of 1 year unless removed earlier or yes, continue to hold office until the nomination has been still made. In order by virtue of this.
So the bylaws can overrule the trustee, is it? Whether the bylaws can overrule the trust deed itself. No.
So, other than plaintiff's certificate. Again, I did not indicate. He has been removed for certain.
That is 36.
I did not state that.
No. This clause which provides for continuation till the next managing committee is elected is only to meet a situation where elections cannot be conducted. within 3 years. Stay, not beyond that. No, please read the term of office. Clause 4, bylaw 4.
The term of office is board of trustees. Coming under the above rules that ordinarily 3 years. Date of nominated or elected as board of trustees. Provided however, it will be removed. Whether it be nominated. Okay, discrepancy or refinement. And operated all the trustees. Provided innocent trustees have completed the experience. Just remove arrears. So need you to do nomination.
Therefore, it does not say that he can continue for the second term.
I'm arguing that we have to remove for some experiment or any
No.
action. Now, second point in my idea is that what is the state they said more would try to and give me
Well,
but I 1994 is the term expect.
yes.
The period record of 2022.
Therefore, the plaintiff in invoice number 12 of 2022 on the file of the 4th additional civil judge in JMFC, Bhadravati, has filed this petition challenging the order dated 15/2/2022 passed therein by which the court rejected an application filed by the plaintiff for interim injunction. The petitioner has also challenged the order passed by the appellate court in May 3 of 2022. Will stop. The suit invoice number 12 of 2022 was filed for a declaration 108, sought for a declaration. Yes. Declaration that the resolution passed by the defendants at the meeting held on 11/8/2021, divesting the plaintiff from the office of president is ab initio void ab initio, and for perpetual injunction restraining the defendants 1, 2, 4, 5, and 6 from functioning as the office bearers of Sri Ganapati Temple and Kalyan Mantapa Trust until the expiry of the term of office of the plaintiff, that is till 5/11/2022, and also for a declaration that the plaintiff is entitled to continue as the function as the president of the Temple and Kalyan Mantapa Trust, and to hold and for a direction to the defendants to hold a lawful election for the office bearers after the completion of the term of the existing committee, that is on 5/11/2022. Next para. The plaintiff claims that he was one of the trustees of the Sri Ganapati Temple and Kalyana Mantapa Trust, Bhadravati. And was later elected as a president of the said trust, president of the managing committee of the trust on Yavatu on 10/8/2016. Full stop. His term came to an end on 10/8/2019. Full stop. The committee of management extended the term for a period of 3 years from 6/11/2019 to 5/11/2022. Full stop. He alleged that the defendants were persistently calling upon the plaintiff to hold a meeting of the trust and had addressed letters dated 9/7/21 and 12/7/21. Full stop. The petitioner, who was responsible for conduct of a meeting, replied to the said letters, calling upon the defendants to indicate the reason for holding such a meeting, indicate the agenda for holding a meeting. Full stop. He stated that since there was no agenda, he did not convene any meeting as requested by the defendants. Please sit down. Full stop. Thereafter, the defendant sent a notice dated 31/7/2021 to call a special meeting within 7 days, failing which the remaining trustees would hold a meeting under the chairmanship of the honorary president. Full stop. Consequent to such meeting, such notice, the meeting was held and the defendants 1, 2, 5, 1, 2, 4, 5, 6 were elected as the president, vice president, secretary, joint secretary and treasurer of the committee of management of the trust. Full stop. Being agreed by the said election, the petitioner filed the suit for the reliefs mentioned above, primarily contending that his term as the president of the trust board of trustees came to an end on 5/11/2022, and therefore he could not have been removed from the post of president. Full stop. An application for interim injunction was also filed by the plaintiff to restrain the defendants from interfering with his performance of duties as a president of the trust. Full stop. The defendants contested the suit and claimed that the plaintiff was entitled to be a president of the board of trustees for a period of 3 years and not beyond 3 years, as per the trustee. Full stop. They claim that notwithstanding such a stipulation in the trustee, the plaintiff continued as a president of the trust, and therefore, the existing trustees felt that the continuation of the plaintiff as the president of the trust militated against the purpose of the trust, and hence persistently called upon the plaintiff to conduct meetings which did not evoke any positive response. Full stop. Therefore, they issued a final notice dated 31/7/21, calling upon the plaintiff to conduct a meeting to discuss about the discontinuation of the services of the petitioner as the president of the board of trust. However, the plaintiff did not heed to the request of the defendants, which compelled them to hold a meeting of the trustees and elect a committee of management of the trust. Full stop. He further contended that the plaintiff had carried away the resolution book and other books relating to the trust, which must have been kept in the office of the trust. Full stop. They contended that the plaintiff was acting against the interest of the trust, and therefore, the plaintiff was not entitled to continue as the president of the trust beyond 3 years. They also opposed the application for an interim injunction. The trial court, after considering the contentions urged, held that the plaintiff is not entitled for interim injunction as the case as interim injunction, since the case involved substantial consideration of facts, substantial facts, and full stop. An appeal preferred by the plaintiff before the appellate court in MA number so was also rejected. Full stop. The appellate court, while disposing of the appeal, held that though the plaintiff had made out a prima facie case, but still the balance of convenience and comparative hardship was in favor of the defendants, and hence confirmed the order of the trial court rejecting the application for interim injunction. Being agreed by the said order, the present petition is filed. Learned counsel for the petitioner submitted that the appellate court, having held that the plaintiff had made out a prima facie case, ought to have granted an order of injunction and could not have refused it on the ground that the question of inconvenience and comparative hardship was in favor of the defendants. The learned counsel submitted that there was no hardship that would be caused to the defendants, inasmuch as there was no serious allegation of misappropriation or misapplication of the funds of the trust. Full stop. He submitted that the term of the petitioner is to end by 5th of November 2022, and therefore, no hardship would be caused to the defendants. Next, per contra, the learned counsel for the defendant submitted that the petitioner had taken unilateral decisions regarding the painting and other civil works undertaken in the temple and the Kalyan Mandapa without taking the other members of the board of trustees into confidence. He submitted that the plaintiff had stonewalled the efforts of the defendants to convince him to conduct a meeting which compelled them to issue a notice dated 31/7/2021 to 21, calling upon the plaintiff to conduct a meeting, which too was not conducted, and therefore the defendants were forced to hold a meeting whereat the board of management was elected. Full stop. He submitted that the plaintiff was conducting the affairs of the trust as if it was his private property, and was taking decisions unilaterally, and therefore, reinstalling the plaintiff as the president of the trust would go against the trustee as well as the intention of the trustees. Stop. I consider the submission made by the learned counsel for the practice. Stop. The trustee provides for the term of office of the board of trustees. Which reads as follows. Page number 80. AB 80 and clause 4A, B, and C. Stop. The bylaws which are framed by the trust indicates the term of office of the board of trustees as follows. Page 86, clause number 4. Stop. A reading of the above clauses leaves no doubt that the period of the Board of Trustees is 3 years. And they could be co-opted by the existing trustees to ensure that the total number of trustees is 15. Full stop. The tenure of the trustee indicates that the term of office of the Board of Trustees is only 3 years and not beyond. So in the case on hand, the plaintiff does not dispute the fact that he was elected as a president of the Board of Trustees for the first term of 3 years, which expired on 6/11/2019. Full stop. His term again was extended for a period of 6/11 for a period covering 6/11/2019 to 5/11/2022, which in fact was against the intention of the trustees. And therefore, the continuation of the office of the plaintiff as the president of the trust was against the trustee per se. A coordinate bench of this court, when considering the power of expulsion in the absence of a provision providing in the deed constituting such association, held that the authority to exercise power of motion, AMOTION, is explicit and implicit. And therefore, even if the document constituting such an association does not provide for removal of such president, the trustees are bound to be invested with such power to remove a person who is holding the post against the trustee. Full stop. The trial court as well as the appellate court has considered these facts and has rightly come to the conclusion that granting an order of injunction, interim injunction, would amount to reinstalling the plaintiff into the post of president, which was against the trustee as well as the bylaws of the trust. Full stop. Even otherwise, the question whether the plaintiff was entitled to continue to officiate as the president of the trust and whether there was any allegations made against him which necessitated the trustees to remove him from the post of president and whether such allegations were justified, are all questions of fact that need to be considered at the trial. Full stop. Since the courts have prima facie rendered a finding that the plaintiff is not entitled to an interim ex parte order of injunction, this court does not consider it appropriate to disturb the same in exercise of power under Article 226 of the Constitution of India. There is a situation lacks very
I appear for the petitioners, my lords. I appear for the petitioner.
Yes, sir.
I'm sorry, I'm appearing through virtual, my lord. This is a case where in the regular first appeal, a compromise was entered into. I'll just give 2-3 facts before I read the order. The compromise was entered into. Certain obligation on the part of the decree holder and certain obligation on the part of the respondents were agreed to be performed. And the decree says within 1 week, the entire obligation has to be performed. In the event of not performing within a week, the the decree can be executed. Minutes. Now, then the respondents have filed an execution.
Find out one Chetan Tayal. Yes, please go on.
Yes, my lord.
Both of you have no objection. I say I have indicated my mind. If both of you do not have any objection, take it up.
Not in my life, I never
Faintly
say.
remember these names, Adike.
Not in my life, I never raised this question of objection. That is how, my lord. First hearing, I said, I have no
Yes.
objection from my
Please,
part.
please go on. Please go on.
Not in execution number 1566 of 2012. One execution is filed by the respondent. Then another execution 12565 of 2012 was filed by the petitioner before a lordship's matter. Then earlier we filed an objection statement on the maintainability. The decree has to be registered one. That order was passed, holding that it need not be registered. Then a writ petition was filed. Writ was rejected. SLP was also dismissed. Then, my lords, the short point for your lordship's kind consideration is.
Let us see Annexure J.
Yes.
Let us understand what is the case all about.
Yes.
Please be seated, madam. Please be seated. Yes.
In fact, I filed an application to club both the matters, so because it is reciprocal obligation. Page 95, my lord, the last annexure is the typed copy.
Yes.
Annexure J. This
Can you repeat
application
this?
is filed by the judgment under section 151 of the CPC on so for dismissing the execution as premature and not maintainable. It is contained in the affidavit of the judgment letter that the subject matter involved in original source on the file of this court was ejectment of the decree holders from scheduled property, whereas a compromise petition filed before the Honorable High Court of Karnataka was altogether different, and a compromise decree containing a new subject matter or property other than the suit property cannot be enforced. Therefore, the present execution petition in respect of the property included in the compromise petition other than the property shown in the original suits is not maintainable. It is further contended that the compromise decree requires registration in the present case. The compromise decree is not registered, and further the plaintiff himself has not complied with the terms of the compromise, and without performing the part of his obligation, he filed the above execution petition, and therefore the execution petition is premature and liable to be set aside. The advocate for the decree holder argued on the application without filing objection or the argument. The points that arise for consideration whether the application filed by judgment letter is sustainable. My answer to the above is as so and so. Reasoning. In support of the contention, the counsel for the judgment letter has relied upon the decision reported in 96 SCC 196. In the said decision, it is held that the compromise, if it relates to new rights, is compulsory registrable document. But in the instant case, compromise decree passed by the High Court of Karnataka does not create any rights or title in favor of the parties, but it merely declares the rights of the parties. And by virtue of the said compromise decree, the sale proceeds are yet to be registered before sub-registrar to get title. The judgment letter has raised another question that the compromise decree containing the terms which are not related to the suit property and the subject matter cannot be enforced in this regard. He relied upon the two old decisions reported in so and so 60 Madhya Pradesh 67. The said decision are in respect of the old provisions order 23. But later in 77, the CPC was amended. Thereby, the parties are permitted to enter into compromise, not only in respect of the suit property, but also other properties matter, which are not involved in the suit. Therefore, in with amended provisions of Order 23, Rule 3, the parties are entitled to enter into whether or not the subject matter of the compromise is the same as the subject matter of the suit. Mullah, this is where something is required to be observed. However, the judgment letter cannot raise such contention before this court, and the duty of this court is to enforce the said decree without reopening the fresh
Where is
question.
the compromise decree?
Lord, I have produced the compromise memo, but decree, my lord, I have passed on. The lordship gets at Annex area page 16.
Sir, yeah.
Yes,
There is actually a compromise filed before the High Court.
yes, my lord, High Court. Lord, all that my limited, in fact, I filed an application to club both the execution petition in a separate application. The court proceeding only in one execution, and my execution petition is not touching. That is the main grievance of the petitioner before your lordship.
Please argue what is the compromise?
Not by page 16, may I read not the compromise?
sir.
That the respondent is the absolute owner of Radha Krishna complex, number 1/1 3rd class KB Temple Road, 6th block, Rajajinagar, Bangalore. In consideration of the respondent agreeing to transfer absolutely clear ownership, free of all encumbrance by registering the sale deeds at respondent card and delivering the vacant possession to the appellant number 2000 square feet, super built area in the floor of the second floor of building known as Radha Krishna complex number so and so, 6th block, Rajajinagar, Bangalore, and within a week from the date of recording of this compromise by High Court to the appellant by registering the office, time being the same, the appellant being relinquishes his rights over all other portions of the building, including the 3 premises which are the subject matter of these appeals. 2, 3. The appellant who is in possession of the basement first floor office in the building known as ground floor, formerly Chachi Towers at number 50 Residence Road, will re-deliver possession of the same to the residence company concurrently with the transfer contemplated in para 2. The respondent further represent that they are the owners of the apartment in Saleh Arekadia, Richmond Road, Bangalore, and the respondent company and the directors hereby undertake to transfer absolutely clear ownership free from encumbrance by registering the sale deeds at appellant cost in respect of the plot number 201 and 205 given on rent, each measuring 1,702 square feet, situated at Salega Arekadia apartment, Richmond Road, Bangalore, fully furnished as per the settlement and delivered possession by adjournment of tenants, and simultaneously by appellant will return all promissory notes in totality signed by Chetan P. Tayal and Mr. Kusum Tayal and his family members and his companies, including the checks in possession of the appellant and the respondent number 3 and 4 and their associates alliance in totally. The terms and conditions, obligations contained in para 2.3 and 4 shall be performed by the parties, appellants and respondents simultaneously within a week from the date of recording the compromise by High Court. In the event of either party failing to fulfill their obligations in terms of the agreement as contained in para 2.3 and 4, this compromise can be enforced against the defaulting party in respect of those obligations without need of further declaration of right by any court of law, and it shall be executable decree. The appellant has no obligation to the appellant taking possession of the premises immediately on the 3rd floor, which are the subject matter of these appeals, and sealed on the attachment of this annual report, and as delivered possession to the respondent and other areas. The respondent and all his directors hereby expressly undertake that prosecution initiated by them against the appellant, his wife and Mr. Chaturbuji L and Maya C, which is pending in CC number so and so, on the file of first additional ACMM Bangalore will be settled unconditionally, withdrawing all allegation made against the appellant, his wife and others. The respondent P. Tayal and Kusum Tayal and his director would file an application for compound. Such are the offences which are compoundable by filing an appropriate application in the said cases, as advised by the appellant by, and in some of the offences alleged are not compoundable, the appellant and the respondent will file a joint petition to seek quashing of the proceedings in the High Court. But however, the High Court is requested to quash these cases pursuant to this compromise in the exercise of power under section 482 of the CRPC. The appellant undertake that he will withdraw all the cases immediately within a week filed against the respondent and their directors, including the cases filed in the courts detailed below. OS number so and so, CC number so and so, writ appeal pending. The appellant, Ms. Mohammad Nizar, withdraws all the allegation made against the respondent and their company and request the Sanal Court to drop the contempt proceedings in CC number 1 of 2000, as the difference between the parties is amicably settled. The appellant today has no objection to the respondent and its director seeking indulgence of the Honorable High Court to drop the proceedings in contempt against CC number 1 of 2007 in where the parties settle the matters amicably, or in the alternative, both the parties to file a joint application petition to seek drop of the proceedings. However, this High Court is requested to quash the contempt proceeding pursuant to the compromise in the exercise power. The appellant compromise 2 to 3 and the respondent company, including the transferee, alliances and associates, and any other claiming through them have no future claims against each other, and all claims are settled in full and satisfaction of all. The respondent number 1, Chaturbuji, and the respondent number 3, Srimati Maya C, have transferred their entire sharings at par in the company Chayachi Hotel, Gold Coins Hotels and Resorts Limited, now known as Renown Hotels and Resorts Limited, to Kusum Tayal, and received the full consideration from Kusum Tayal. Both the parties have no other claims against each other or indefinitely. In here, the subject matter in the appeals is being compromised between the first and the appellant. The interest of the second and third respondent would not survive at all, and the second and the third respondents have no further claim or interest against the first respondents and their directors, and the appellant or vice versa. This is how the compromise state. There is one order passed in the earlier writ petition. I just wanted to read that. This is an order which has been confirmed in the SLP, page 21, Annexure B.
Yes.
But there are some grievances against the respondents, and the petition has been filed. Paragraph 5, my lord, if your lordships can take.
Yes, sir.
The learned judge at the executing court has held that there is no prima facie to hold that the judgment debtor 1 had issued 590 blanks pronotes and 5 share certificates worth of 3 crores to the decree holders, and there is no reference to these documents in the compromise petition or in the compromise decree. The judgment debtors have produced copies of the blank pronotes for different amount and have been signed by the judgment debtor 1. These documents do not bear any date or names of persons in whose pronotes are executed. The judgment debtor 1 appears to have created a photostat copies of on-demand pronotes to make a false claim with the sole intention to drag on execution. In para 5, the compromise decree made by this court in arbitration also. In the event of either party failing to fulfill their obligation in terms of the agreement as contained in para 2, 3, 4, this compromise can be enforced against the defaulting party in respect of those obligations without need of further declaration of right by any court, and it shall be executed. In view of what has been stated compromise petition, the judgment number letter 1 is at liberty to enforce the terms of the compromise decree against the decree holders if they have committed any default or if they have failed to perform their any acts which they are bound to perform in terms of the compromise decree. The learned judge of the executing court has held that the judgment letter has been in occupation of the premises and getting a huge rents from the tenants and is protracting the execution proceeding without any valid cause or reason. The executing court has rejected the objection filed by the judgment letter 1. Therefore, the judgment letter 1 is before the court seeking for a writ of certiorari to quash annexure T. The order made in execution 1566 of 2012 dated so and so. The judgment letter 1 has also sought for a writ of prohibition to restrain the executing court from executing it for future to discharge their obligation in terms of the compromise decree. The judgment letter 1 has also sought for alternative remedy of execution to the execution court so and so decree, along with 2565 of 2000 filed by the judgment letter. Then Millard's para 10. Before adverting the submission made with the counsel for parties, it is necessary to refer to the judgment of the Supreme Court in 2010. In case of so and so, to understand the scope of the jurisdiction of this court in a writ petition under Article 226 of the Constitution. The High Court cannot, in the guise of exercising jurisdiction under Article 2, cannot convert into a court of appeal when the legislature has not conferred the right of appeal. And so Navajyoti Sindhu, this court has explained the power. Then, my lord, I need not have to read this. Yulashme kindly come to paragraph 11. The learned counsel for judgment letter has relied on the judgment of the Supreme Court in 2006 5 SCC 566 to contend that unless there is a lawful agreement or a compromise in writing, the decree cannot be executed by the executing court. The learned counsel for the judgment has relied upon a judgment of so to contend that unless the compromise is registered, it cannot be executed. The learned counsel for judgment has also relied on AIR of 1941 Bombay 17 to contend that all sections so wide enough to cover all decrees, whether made prior to or simultaneously with the assignment. The learned counsel for the judgment has relied on the judgment of the Supreme Court in Bob Singh case to contend compromise decree creates rights for the first time. It shall be registered in terms of 17(2) of the Act. The learned counsel for the judgment letter would submit for the future of the decree holder to discharge their obligation in terms of the compromise decree. The judgment letter is not liable to execute the sale deed in terms of the compromise deed. The learned counsel for the decree holders would submit. Decree holders have discharged their obligation in terms of compromise decree. The allegation made by the judgment that decree holders have failed to discharge their obligation in terms of the compromise declared basis. The judgment letter has superimposed the terms which are not found in the compromise petition or decree. Therefore, the learned counsel, the learned judge has rightly dismissed the application. In a decision reported in AIR 72 Supreme Court 137, the Honorable Supreme Court has said, it is true that an executing cannot go beyond the decree and the decree, but that does not mean the duty to find out the true effect of that decree. For construing a decree, it can, and in appropriate cases, it ought to take into consideration the pleadings as well as the proceedings before leading up to a decree. In order to find out the meaning of the words employed in the decree, often it has to ascertain the circumstances under which those words came to be used. That is the plain duty of the execution court, and if that court fails to discharge that it has plainly failed to exercise the jurisdiction began, ended with merely looking at the degree it was finally adopted. In the case on hand, the learned judge of the executing court has taken into consideration the circumstances under which the compromise petition was filed in so-and-so. The learned judge of the executing court has considered material relied upon a decree holders to come to the conclusion the decree holders have discharged their obligation in terms of the compromise decree. The learned judge of the executing held in order to dispel the apprehension the decree holders have executed indemnity bond therein. The decree holders have declared that except the pronouns which they have produced before the court, the decree holders are not in possession of any of the pronouns as contended by the judgment debtor 1, and without prejudice to the aforesaid declaration, they would indemnify the judgment debtor if any action is instituted on the basis of the pronouns referred to by judgment debtor number 1. In the first objection statement filed by the judgment debtor number 1 on 1910, the judgment debtor 1 has contended the decree holder has not withdrawn the case in so-and-so and also not returned the original checks of 90 lakhs in spite of several requests. The decree holders have not returned all original pronouns, share certificates, and signed checks of by Chetan Pitayal and Kusum Tal in their individual capacity on the basis of the compromise. The decree holders have not handed over the vacant possession of premises number 64, the first floor in the building known as so-and-so. In the second objection statement filed by the judgment debtor on 24/11, the judgment debtor has contended that the decree holder are in possession of 590 demand pronouns valued at 208.85 lakhs. They are already holding about 60 original on-demand promissory notes. The judgment debtor on receipt of the cause of notice of execution was expected to file statement of objection raising all pleas available to him to resist the execution petition. The judgment debtor number 1 should not have reserved pleas to raise them by second statement of objection and third statement of objection, as the law does not give right to judgment debtor to file statement of objections on installment basis, raising different pleas at different stages. The learned judge of the executing court has verified the objection statement filed by the judgment debtor on various pleas raised by them with reference to the terms of the compromise and document both parties to arrive at a conclusion, and the decree holders have discharged their obligation in terms of compromise decree. The learned judge of the executing court has held that the demand made by the judgment debtor on return of 590 is not one of the terms of the compromise decree. At this juncture, it is necessary to refer to clause 4A. The respondent further represents that they are the owners of the apartments of Saleka Arcada, Richmond Town, and the respondent company and the directors hereby undertake to transfer absolutely clear ownership free of all encumbrance by registering the salutes appellant cost in flat number 201-205 on rent, each by measuring 1702 square feet, situated so-and-so, fully furnished as settlement and deliver possession by allotment of tenant. Simultaneously, appellant will return all pronouns in totality signed by Chetan P. Tayal and Kusum Tayal and his family member and his companies, including the checks in possession of the appellant and respond number 3 and 4, and that's also. In terms of the clause 4 of the compromise petition, the decree holders are required to return all the pronouns in totality signed by Chetan Pitaya and Kusum Tayal, and also family members, including the checks in their possession. If the judgment debtor was in possession of photostat of 590 on demand note, there was no impediment for judgment debtor to state the same in the compromise petition. Therefore, the trial court has rightly held that the objection filed by the judgment debtor 1 is not that it is not one of the terms of the compromise. The judgment debtor has contended that the compromise is not executable for what registration. In order to appreciate the contention, it is necessary to state that the parties have agreed to execute the registered document pursuant to the compromise decree. The compromise decree by itself does not operate, create, extinguish, or relinquish the rights of immovable property. Therefore, the contention of the judgment debtor that the compromise decree is not executable for want of which it cannot be accepted. Even otherwise, the executing court cannot refuse to execute the decree for want of which, more particularly when it stated in the compromise decree that it shall be registered. The learned counsel for the judgment debtor 1 would submit that the compromise decree apparently does not reveal that the judgment debtor has delivered any benefit under the compromise. The executing court cannot go beyond the terms of the deed. The execution court is not competent to decide the plea raised by the judgment debtor that the compromise decree apparently does not reveal the judgment debtor one has derived any benefit. The learned counsel for the judgment debtor would submit that the judgment debtor has filed execution number 2.65 of 2012 to direct the decree holders to perform their obligation in terms of the compromise. If that is so, the judgment debtor is liberty to establish execution number so and so, the obligation which the decree holders have to perform in terms of the compromise made in RFA number so and so to realize the benefits of decree. At this juncture, it is worthwhile to notice at one stage, the judgment has contended that the compromise document does not reveal the judgment of one has not derived any benefit under the compromise. In the next context, the judgment debtor has there are several obligations with the decree holder has performed in favor of the judgment as per the terms of the contract. In view of the limited scope in 226, then my lord, the petition has been dismissed. And this judgment on SLP is filed, and in the SLP was also dismissed. Now, my lord, I am appealing to Lordship's, my lord, para 25 of the order of this court, that execution number 2565 of 2012 is also filed by me. And
on what ground is the application now filed?
That, my lord, I filed an application. That application was not considered. The impugned order, my lord, before your lordships is the order dated, that is 8/3/2013.
Yes.
This order came to be passed when the sale deed was directed to be, my lord, produced by the plaintiff draft sale deed, and an application has been filed stating that a copy of the sale deed was required to be given to the petitioner in terms of Order 21, Rule 38, my lord. Rule 35, I'm sorry, Rule 34. Wherever, my lord, a decree for execution of a document or negotiable instrument, the under Order 21, Rule 34, the draft sale deed must be given to the petitioner.
Yes.
Then the judgment debtor's right to file objection is preserved. Thereafter, my lord, there is an office objection, my lord. In this case, your lordships get it. I'm sorry. It is at page 75. There is some mistakes in the page 83, my lord, Mayor. Page 83, handwritten is at 75. Page 83, your lordships got it. 12/12/2012.
12/12/2012, yes.
Order sheet. Down, my lord, your lordships get. The judgment and decree copies in OS number not furnished. The value of the scheduled property has not been furnished to evaluate the stamp duty. The boundaries of the scheduled property have not been furnished. Since the compromise other than the subject matter of the suit, a fresh valuation of the property compromise has to be furnished to evaluate and the court fee to be paid. Now, my lord, when the matter was taken up before the apex court, since the decree which was drawn before this court was not produced, then, my lord, it is open to the parties to club both the execution, it is on that context, the SLP was dismissed, of course. The senior advocate who appeared who wrote a letter at that time. I'm not depending upon that, not the manner in which. Now, my lord, the short question is, in the impound order itself, my lord, if your lordships kindly take at page 99.
Yes.
Paragraph 9, my lords, last line, last two lines. In fact, the decree holder has complied most of his obligation only due to obstruction caused by the judgment debtor. Some of the obligations are still pending due to non-cooperation of the judgment debtor. The decree holder is all along ready and willing to perform all parts of the obligation under compromise decree. And however, the judgment debtor is always intended to protract the execution petition one or the other. Therefore, the above application of the judgment debtor, even after rejecting the earlier application by this court, and he is liable to be dismissed with cause. Now, my lords, I filed a separate application, your lordships gets at page 85.
Yes.
I'm sorry.
Club both the execution.
To club both the applications. My lords. To club both the applications and execution petition, and then proceed to pass an order.
Yes.
Page 65. Page 65, annexure F.
Yes.
Now, my lord, there are three things, my lord, which are involved here. Chaturbuji, who are the respondents, 3 and 6. Sorry, 5 and 6. Respondent 2 and 3 in the decree holder, they have been left out in the execution petition. So whenever the decree is satisfied and when the decree is put for execution, the satisfaction of a decree outside the court cannot be accepted. They must also be implicated as a parties, one Mr. Chaturbuji and Maya, wife of Chaturbuji. Respond number 2 and 3. Then, my lord, since the entire decree proceeds on the footing that there is a reciprocal obligation between the parties, all the obligations in an execution should be enforceable at once, my lord, by clubbing both the applications, but not in installment. This is the second issue, my lord.
Which are the two execution? One is filed by Mohammed Nisar.
1566 of 2012.
What is
execution? Execution filed by me is 2565 of 2012. In fact, in earlier occasion, this court granted liberty to proceed with the matter. In fact, so far the registration is concerned, of course, my lord, the matter was referred to the 3 judges in Pulpatti and another versus Ram Singh. This Bhoop Singh case and again Pulpatti case, my lord, has been, and Raghunandan case has been referred to the larger bench, and that came to be decided in 2015, 3 SCC 465. Now, my lord, the law is very clear. If there are more than one properties, or if the subject matter of the property is not the subject matter of a suit, then the registration is a compulsory. Of course, my lord, I have a little scope to argue that issue because there is
it's already covered.
But
this court has already considered that.
That is why, my lord, that is why that issue gets covered. Now, the only two things, my lord, in fact, I relied on Order 21, Rule 19. That I sent the judgment of 1956 Supreme Court, page 359. If there are reciprocal obligations,
Yes,
in a decree,
yes.
then, my lord, the decree has to be executed by following a procedure under Order 21, Rule 19 of the CPC.
Yes.
Suppose, my lord, if there are two decrees passed at different times, but between the parties, then Order 21, Rule 19 would not be applicable. Not AR 1956 Supreme Court has given the judgments, my lords. Paragraph 18.
Page number?
My lord, this is if once a decree imposes an obligations, if both sides which are so conditioned, the performance of which, kindly go to, my lord, paragraph 18.
Yeah.
At page 368. May I read para 18 minutes?
Yes.
AR 56, Supreme Court
So I
359.
got it. It's gone.
No. Much of the argument about this revolved around the question whether the equitable rules that obtained before the decree in a suit for specific performance can continue at the stage of execution. It is not necessary for us to go into that here because the position in the present case is much simpler. When a decree imposes an obligation on both sides, which are so conditioned that performance by one is conditional on performance of the other execution, will not be ordered unless the party seeking execution not only offers to perform his side, but when objection is raised, satisfy the executing court that is in a position to do so. Any other rule would have the effect of varying the conditions of decree, a thing that can executing court cannot do. There may be, of course, decrees where the obligation imposed on each sides are distinct and severable. In such a case, each party will be left to its own execution. But when the obligations are reciprocal and are interlinked so that they cannot be separated, and any attempt to enforce the performance unilaterally would be to defeat the directions in the decree and to go beyond them, which of course an executing court cannot do. The only question therefore is whether the decree in the present case is this nature. We are clear that is the relevant portion of the decree is extracted. Then let's
No, but here it is separate. It is clearly discernible.
No,
not
it is a composite degree. It is a composite decree where the entire obligation has to be performed. The judgment, the decree holder cannot say, I will file a memo that I will stand indemnity if somebody enforces the pronote. That is not the satisfaction of a decree, my lord.
Correct, but now he is willing to comply with his obligations under the decree.
Yes, my
In
lord.
the sense, he will execute some document in respect of the Rajanagar site. Huh? Yes.
In fact, that is also I just wanted. Well, the decree cannot be, if it is reciprocal obligation in one decree, the executing court cannot split the decree, my lords. That is how in 2000, of course, that is the 2003. 10 SCC 189.
2010.
2003, 10 SCC 189 minutes.
Yes.
Paragraph, my lord, 9. It cannot be doubted and disputed that the rights and obligations of the parties stands crystallized into recitals of the compromise decree dated so and so. During the course of hearing, each of the two learned counsel for the parties emphasized the obligation cast by the compromise decree on the opposite party and submitted that the compromise decree spells out reciprocal promises, and in the submission of each of the learned counsel, his party was not obliged to perform its promise unless the opponents performed their reciprocal promises. The compromise decree does not in so many words specify the obligation incurred thereunder by each of the parties to be reciprocal promises. However, each of the learned counsels submit that the promises incorporated in the compromise decree are essentially reciprocal, and unless the other party perform its obligation, it was not necessary for his part to perform his obligation. Thus, in short, blame for non-execution of the compromise decree is held by each one on the other. In our opinion, it would be sufficient to say that the obligation incurred with parties under the compromise cannot be termed reciprocal compromises, independent and each other for performance. All the obligation incurred with the parties under the compromise decree are independent obligation, and each party must perform its obligation directed towards fulfillment and consequent discharge and satisfaction of the decree. To the extent to which controversy survives for adjudication, the same cannot be taken care of by the executing court, which can still compel fulfillment of obligation respectively to the extent to which either party is obliged to do, but has failed in discharging the same. The executing court may issue necessary process, appoint a commissioner, or direct detention to civil prison, so and so. Though the objections are very many, in substance, according to the appellant, they are no longer under obligation to pay the amount of compensation in investment under clause. So they have under clause 3 made early payments and secure waivers, so and so. But this is how there is a direction ultimately, my lord, to execute the decree. Last. Now, my lord, there are two submissions on this, my lord. One is the first decree for execution where the respondents 2 and 3 are not made parties, and there is a relief of the performance of some obligations against Chaturbuji and his wife. Number 2, the execution 12565 of 2012 was also filed to execute the decree, and the trial court in the impugned order itself observed that there are certain obligations still to be performed by the decree holder. Sorry. That is, my lord, the last portion of the impugned order, page 99.
Yes.
There is an observation, obligations are still pending due to non-cooperation of judgment data. There is no prejudice caused if both the decrees are to be clubbed together, execution petitions are clubbed and an orders are to be passed. There are two things, my lord. One is a person who has been implemented as a party in the RFA, some obligations are to be complied. They have been kept out of it. And a memo has been filed stating that I will comply I will prepare to execute the indemnity, but I will stand as a surety. That is not the term of the decree. The decree cannot be altered by the executing court.
Yes, please.
That is my submission. And so far as the draft sale deed is concerned, Order 21, Rule 34, the draft sale deed should be given to us, to the judgment debtor.
Yes.
I will just read minute Order 34.
Yes.
Where a decree.
Copy of the draft sale deed has to be given to you. There is no dispute of.
Yes.
Notice calling upon you to come and execute the sale deed along with the draft copy that has to be furnished.
In fact, I advised the party, my lord, to try to settle the matter. That is why around more than 10-20 times the matter got adjourned. Now, I also feel that once there is a compromise, it has to be respected. But at the same time, that the other aspect of the story is that lot of money is being hanging on them. That is an internal story of business people. We can't enter into that aspect. Lord, I only appeal to your lordship, let the execution petition should be clubbed together. And since it is a reciprocal obligations and both the decrees can be enforceable, since it is a one decree, my lord. One decree, the obligation of one is depend upon the other. Therefore, one decree, final decree can be, one order in execution can be passed.
Yes, sir. Yes, ma'am.
All the failure of decree orders and discharge their obligation with terms of compliance. Judgment letter number 1 has also sought for alternate regulation to execution code to decide execution petition number 1566/12, filed by the executor, along with execution petition number 2565/12, filed by judgment letter number 1. I have heard so and so. And then the court goes on the draft paragraph. On page 43. On hearing the learned counsel parties and going to the interview order, I find that the interview order is within the limits of law and learned judge of the execution order is not transferred to the law. Therefore, there are no grounds to declare the interview order. The petition will and SMP is recorded in the government. And it reflects all the 2011. I want to see this is the sixth round of challenge at the judgment level of case with respect to the same two conventions, which is that there are reciprocal obligations which have not been performed by us.
Where is the judgment of the Supreme Court? Where is the judgment of the Supreme Court? It's all right. It's all right. What is the number? What is the number?
It's only 10049
10049 dash. No, it's all right, don't do. All right, Pana, we'll take a copy.
Yeah, I know the submission with the reciprocal obligations which are not an abstract proposition. Other than compromise, there are 4 obligations imposed upon me. 3 obligations imposed upon the judgment letter. The first obligation is imposed upon me is that the basement and the first floor of whole tower, one residency board, has to be handed over to the judgment letter. I have handed over the basement floor. They have acknowledged receipt of the basement floor. The keys of the first floor have been given to the state deposit of the court. Both the executing court and responsible court has observed that the key is in the state deposit of the executing court and that I have no objection to the key being handed over to them once their obligation is under the second obligation imposed upon me, my lord, with respect to certain checks and certain loans. Now, there was PC 10690 of particular year, which is pending before you. That when I filed the memo before that proceeding, the court, I was to understand the file of the mistake. So I filed a complaint only before the registrar. And I filed a memo and an indemnity form stating that I have 90 lakh worth of checks, original checks, which were custody. So I indemnified the trustee debtor. I will not claim under that. That indemnity form is on record as a notice that executing court in a detailed order and by the there are 35 crores and 5 share certificates which I had, original copies which are manufactured the custody. Reported duly by the executing court, making note of that responsibility. They immediately came up with the argument that there are 590 blank crores worth about 3 crores in my custody and certain other share certificates in my custody, which I have to return to them. Such crores and share certificates are not mentioned in the compromise decree. Both the executing court and the responsible court has noticed that they are currently documented. The courts have also noticed that this ought to have been mentioned in the compromise decree. Even otherwise, I have filed the indemnity form, which is in stating that if there are such criminals, then I indemnify the judgment that I have three consequences that exist from both. The third, my lord, obligation of funding is the OS 389 CC 960 which I have duly withdrawn. I was also to withdraw patent which I have duly withdrawn. I have therefore complete satisfaction of all conditions under the decree before the following. The judgment debtor's obligations are going to execute the registered statement to the second to other which they have not done. They would have executed registered statement with respect to platform numbers 20165 in Sale Arcadia, Arcadia, and President, which they have not done. They not only litigate against me 6 times, but also during the pendency of the litigation on 2013, illegally entered into a release deed and paid of their dollars in respect of the state properties only in order to defeat this. They have to withdraw 2 petitions against me, which they have done. That is literally the only obligation they put to the their obligations remain unperformed. And instead of performing their obligations, they have merely been litigating the matter of the same contention. Every single time, the same contention is created.
Please file a memo. Please file a memo as to what all you have complained with.
We don't know what the condition is. That is already a record. There is a memo that has been filed.
What is complained by you and what is outstanding? When was it filed? Anything else? That's it.
Just one or two other publications, my lord. The conditions we have taken are all government efforts.
Not necessary, madam. That is not.
Because the contention that compromise if you are to be eligible is also in most of the.
Yes, that I verified. I have seen.
Other public properties, number and draft sale in page 71 and page 76. I also think be punished. On 2 occasions before the according to the
Yes. Please hand over a memo. You have extra copy. It's for taking judgment on. 31st. I know what 30th. I will take a copy, don't you?
One thing I didn't mention, Millard.
Yeah.
These properties, Millard, the daughter filed a suit for partition in view of the.
No, that we are not concerned. We are not concerned.
No, that issue is pending, and
we are
I
not
also
concerned with
no, that is why I did not. I am only just bringing to lodges. obligations of the respondent 1 and 2 under the compromise, then were not complied. I prepared a chart note. We'll pass it on tomorrow itself.
Please pass it on, please pass it.
Please, please.
Mr. Basuraj. Notice for what? Yes, I already seen it.
But I consider it a property. But respect of property, but continuing for one.
No.
But an extent of 2 acres. And when the
From whom did you purchase?
from the investment.
Basuraj. What is the date of decree? And you purchased in 2014.
Not existed. I will provide the property property that has been purchased.
Let the court decide that. Let the court decide it.
They decided that the application is now amendment application has been filed by the respondent number 5. Only application is not the body and the body of legal principle in their this is subject to the property limit has been diverted.
Please show us Basurajaya possessed 5 acres of land in survey number 13 and Torsu. Please show how Basurajaya possessed 5 acres of land.
Landed in the under the landed concept. But I have produced the card.
No. You had purchased 2 acres, correct?
Yes, sir.
Basurajaya sold 3 acres to Kushalabai under the agreement. So Basurajaya must have had 5 acres of land. In some survey number, it could be 39, 39/1, 38, 37, 36. But yellow one kada 5 acre irbo. Illide toosu. We're not on that. Forget the survey number. Forget the survey number. Show that Basurajaya had got 5 acres of land. In whichever survey number. Yes. There's no dispute. So Basurajaya survey number 39 5 acre ತೋರಿಸಬೇಕು. Forget the survey number, sir. Forget the survey number. See, you cannot sell what you did not have. Correct? He cannot sell what he did not have. So what did Basarajaya have? ಮತ್ತೆ ಅದನ್ನ let him show.
The execution without amending, without the record date and without amending the date, and without the amending the date. That's right away when they find the 16 say that by virtue of the phone and drawing, this the 7 number has been bifurcated and this subject matter of the two has been bifurcated.
Dependent, not having this law. There are tendency after the degree. You are secretary of the before the then you are inviting. And we apply for after the coding, keep up there. Correct. Mentioning the same children. Same voltage as indicated on the code. That we ask for. The subsequent to the coding, either we are not.
What is the extent after the coding? 3 acres. 2 acres, 2 guntas ಅಂತ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
Bifurcate ಮಾಡಬೇಕು. That is after the coding is done. Mentioning the same number, real facility is there. On 24/7, 2020,
ಮೂರು ಎಕರೆ ಅಂತ ಎಲ್ಲಿದೆ? 39 ಬಾರ್ ನಿಮ್ಗೆ ಯಾವ್ದು ಕೋಡಿ ಆಗಿದ್ಮೇಲೆ 39 ಬಾರ್ 1P ನಲ್ಲಿ 3 acres ಇದೆ. ದುರಸ್ತ ಆದ್ಮೇಲೆ ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಬಂತು? 39 ಬಾರ್ ಹಾ
So degree is solved number
39 ಬಾರ್ 1 ಮತ್ತೆ
39 ಬಾರ್ 5.
But these two properties are situated separately. ಮಧ್ಯ 4 ಬರುತ್ತಲ್ಲ, ಮಧ್ಯದಲ್ಲಿ 4 ಬರುತ್ತಲ್ಲ ಸರ್. ನಾಲ್ಕು ಮಧ್ಯ ಬಂತಲ್ಲ. Please come to Annexure D, page 41. ಮಧ್ಯದಲ್ಲಿ 4 ಬಂತಲ್ಲ. 4 ಅಲ್ಲ 4 1 2 3 4 4 ಬಂತಲ್ಲ, ಅದೆಲ್ಲ ಆಗುತ್ತೆ. What happens to 4? Not Manisha Dadri. 39 ಬಾರ್ 4 ಯಾರಿಗೆ ಸೇರಿದ್ದು? 39 ಬಾರ್ 4 ಯಾರಿಗೆ ಸೇರಿದ್ದು?
ಅದು 1976 ಅಲ್ಲಿ we have
Now by virtue of this decree, decree is in respect of the boundaries which are mentioned in the agreement. Correct? Now the boundaries have changed. Why not changed? 39/1 ಗೆ boundaries ಕೊಡಿ sir. 39/1. Please give the boundaries for 39. ತಡೀರಿ ಒಂದು ನಿಮಿಷ.
39/1
ಆಯ್ತು 39/1 ಪೂರ್ವಕ್ಕೆ ಬಾಲಪ್ಪ, ಪಶ್ಚಿಮಕ್ಕೆ ಬಾಲಪ್ಪ. ಇವಾಗ ಬನ್ನಿ ನಿಮ್ ಚೆಕ್ ಬಂದಿಗೆ ಬನ್ನಿ. ಪಶ್ಚಿಮಕ್ಕೆ ಯಾರಿದ್ದಾರೆ? ಬೋರ್ಡಿ ಯಲ್ಲಪ್ಪ. ನಾರ್ತ್ ಬಿಟ್ಬಿಡಿ, ನಾರ್ತ್ ಏನ್ ತೊಂದರೆ ಆಗಲ್ಲ. ಪಶ್ಚಿಮಕ್ಕೆ ಯಾರು ಬರ್ತಾರೆ? How can, without getting the boundaries changed, how can you get a shaded is what I am asking you. Sir, I understood what you are saying. I understood what you are trying to tell me. Before POD, you should have got a sale deed. Now you want you have got the POD done, and renumber is the survey numbers are renumbered. You want a sale deed for the resurveyed number. The boundaries are which are different. How can you get a decree in respect of a different boundary unless you amend the decree?
He has been a litigation. He cannot question this order record because whether he after even the dismissal of the RSA, degree and after the POD has been done at my instance, mentioning the same POD number, mentioning the same title deed, he contains this matter.
Yes, Mr. ಅದು ಫಸ್ಟ್ ಹೇಳಿ ಲೋಕಲ್ ಸ್ಟ್ಯಾಂಡ್ ಬಗ್ಗೆ 101. What is the sale deed then? ಬಸವರಾಜ ಬರ್ಕೊಟ್ರು. ಯಾವುದು? ಯಾವ ಸರ್ವೆ ನಂಬರ್? ಸಂಖ್ಯೆದಲ್ಲಿ ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಹೇಳಿ? ಇದು ಸೇಲ್ ಡೀಡ್ ಓದಿ 39. ಈ 39/1 ಯಾವಾಗ ಆಯ್ತು? 39/1 ಇರೋದು 2 ಎಕರೆ. 39/1 ಇರೋದು 2 ಎಕರೆ. ನಿಮ್ಗೆ ಯಾವಾಗ ಆಯ್ತು 39/1? After the POD only. POD ಆದ್ಮೇಲೆ 39/1 ಬರ್ಸ್ಕೊಂಡಿದ್ದೀರಿ. And what is your right? In view of order 21 rule 102 na? 102 na? Is it 102? Not 2 alva. Hmm, 102. Please come to order 21 rule 102. So what is your right? First of all, why don't you, what is your right to challenge? What is your right? You are a pendant purchaser. What is your right?
I was not included in the execution.
Correct. Yes.
Their number.
Because you are a subsequent purchaser. So therefore, when a decree of special performance is granted, you also have to be included. How will your sale deed be liquidated? ಈಗ ಒಂದೇ ಪ್ರಾಪರ್ಟಿ ಎರಡು ಸೇಲ್ ಡೀಡ್ ಇರುತ್ತೆ, ಅದನ್ನ ಅವಾಯ್ಡ್ ಮಾಡೋದಕ್ಕೋಸ್ಕರ ಎಲ್ಲಾರನ್ನು ಸೇರಿಸೋದು. ಸೊ ಬಸವರಾಜ ಗಾಟ್ 5 acres ಅಂತ ತೋರಿಸ್ಬಿಡಿ. Learned counsel for the petitioner submits that Basurajaya, the judgment debtor, possessed 5 acres of land in survey number 39/1P, alwa 39/1P, and that the property purchased by the petitioner measuring 2 acres is different than the property which is sold to the decree holder in terms of the agreement of sale. Stop. No. Basurajin 5 acres ಎಲ್ಲಿಂದ ಬರುತ್ತೆ? So now that you have made a claim, you may have to get ready to pay cost if you don't show this list on when do you want? Put it in date, put it. Part of the case. And then Sebastian.
I appear for the petitioner.
Yes.
Let me taken up for vacation, Madam. Time is over.
Madam, time is still there, madam. Another 6 minutes is there if you can complete.
No, it won't be over.
No, I'll sit up to 5:30 if you are willing to.
No, I must be able to sit, not well.
Yes, Mr. Sebastian.
I was waiting since morning. In fact, my throat is also not well. I can't address the arguments.
Even counsel for the petition respondent seats time list on 20th October.
Yes, madam.
20th. Yes.
Imbadar Gouda. Kamala. Oh, this is the section 8. You are already done. Don't yes. Speed up. Yes, Mr.
In relation to such a thing, there contains there's a land development agreement. The land development agreement are an arbitrary parties are so it comes to Lord Mysore. But there's a arbitration not made. Any scheme Lord. Every same land development agreement. Every same land development agreement also referred to by the claim. In relation to this land development agreement, not about But we see the parties do not. The plaintiff in this suit do not. The defendant in the other suit.
Yes.
While not the defendant do not is the plaintiff. So do not the managing partner also is where the secretary. Not matter about the. Therefore, my submission is allowed to be. Well, it is an act that arises out of the matter of the. And if the allegations do not are related to the matter of the.
Yes.
Then, my lord, it is certainly a case where my lord is related to car.
Yes. What is this? Mr. Adjourn ಮಾಡೋದು ನಾಳೆ ಇದು ಬೇರೆ ಕೇಸ್ಗಳು ಬರುತ್ತಲ್ಲಪ್ಪ ಲಿಸ್ಟ್ counsel for the petitioner. Counsel for the petitioner has placed on record a copy of the plaintiff invoice number 25138 of 2014, which was filed on the basis of the joint development agreement dated 29/9/2009, which incidentally was also the basis of the suit invoice number 1343 of 2012. The legal counsel for the respondent seeks and list on I don't want to clutter my cupboard. There are already a lot of matters pending for passing judgment. Now, not on date. October 19th October. For further hearing. Tomorrow is extended in the next date of hearing. There is no representation for the petitioner. The petition is dismissed for non-prosecution. You're appointed. What's your report? Report. Whom does it favor, madam? Whom does it favor? What your commissioner fee? Need anything more? What is found in this? Ian, what was the subject matter? Madam, you can please be seated. Please be seated. If there's anything, I'll call you. Yes, sir.
They have filed objection content that Commissioner has not issued notice to any actor. Or particularly the actor. We have not attended the survey in our presence and separated the report. They are in the.
ಇವಾಗ ಇದು ನಿಮ್ಗೆ ಅಕ್ಸೆಪ್ಟಬಲ್
acceptable ಅಲ್ಲ ಇದು there is a way to deviations in the examiner.
ಏನ್ ಹೇಳಿ
ಅಲ್ಲದೆ earlier commissioner report ಅಲ್ಲಿ I also should have closed down the retribution of page number 24. The measurement of the property is after the volatile fee. How the commissioner has submitted a claim, it measures 1% DD. So this has to be approved with the party.
No, but please tell us whether the measurement found by the commissioner is correct or not. It was done in your presence. With all of you accept that this measurement is correct. Where is the commissioner sketch prepared in the FDP? FDP ಏನಿದೆ?
24.
Page number 24. Here.
Commission has opened mistake. And back up to so means underline and after
54 108 ಪ್ಲಸ್ ಅರ್ಧ ಇದೆಯಲ್ಲ.
Taken by the commissioner. Without giving the opportunity of showing the property and conducting the survey in our absence. Therefore, the national participating in our argument has ordered the appointed commissioner stating if there is any variations in the commissioner report, no variations in the report, this is not it. And I request the national to read paragraph 2 of the argument. Contractor number comes from the response of the fact that not having it, objection of that. Has divided the property into 4 equal parts and has given the element of these two shares. Therefore, there is no discrepancy. He submits that his claims have no objection for the appointment of then there is no need to set the brand of the authority. So, all the judge saying that earlier, so
ಆಯ್ತು, why don't you cut the long short, story short? ಇವಾಗ ಇದು ಒಪ್ಕೊಂತೀರಾ? ಅದನ್ನ ಆಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡೋಣ. ಮೆಜರ್ಮೆಂಟ್ ಎಲ್ಲ ಸರಿಗಿದ್ಯಾ? You have any objection to this sketch? Yes. ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು ಹೇಳಿ? Which portion do you want? ಅಲ್ಲ, which portion do you want, sir? This no ಇವಾಗ ಹೇಳಿ. ಇವಾಗ ಹೇಳ್ಬಿಡಿ. ಇವಾಗ ಎಲ್ಲಾನು ಕರೆಕ್ಟ್ ಈಕ್ವಲ್ ಡಿವೈಡ್ ಮಾಡಿದ್ರೆ 922.5 ಸ್ಕ್ವೇರ್ ಫೀಟ್. ಇವಾಗ ಹೇಳಿ, ಕ್ಲೋಸ್ ಮಾಡೋಣ. ಅದೆಲ್ಲ ಮಾಡೋಣ. ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು ಹೇಳಿ ಇದ್ರಲ್ಲಿ. ಅದು ಯು ಶುಡ್ ಹ್ಯಾವ್ ಡನ್ ಇಟ್ ಬೈ ನೌ. ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು? ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕೋ ತಗೊಳ್ಳಿ. ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕೋ ತಗೊಳ್ಳಿ. ಮಿಕ್ಕಿದವ್ರು ತಗೋತಾರ. ಇವಾಗ 4 ಪೋರ್ಷನ್ ಸಪರೇಟ್ ಎಂಟ್ರೆನ್ಸ್ ಇದೆಯಾ? ಎಂಟ್ರೆನ್ಸ್ ಕನ್ಸರ್ವೆನ್ಸ್ ಆಯ್ತು. ಕನ್ಸರ್ವೆನ್ಸಿ ಅಂತ ಎಂಟ್ರೆನ್ಸ್ ಇದೆ. ಇಬ್ರಿಗೂ ಸಿಗುತ್ತಲ್ಲ 1-2ಗೆ. ಈ ಕಡೆ 3-4ಗೆ 30 feet ರೋಡ್ ಇದೆಯಲ್ಲ, ಎರಡು ಕಡೆ ಸಿಗುತ್ತೆ. So what is the problem? ಆಯ್ತು, ನೀವು ಫ್ರಂಟ್ ದೇ ತಗೊಳ್ಳಿ, ಬ್ಯಾಕ್ ದವ್ರು ಕೊಡಿ. ಫ್ರಂಟ್ ದೇ ತಗೊಳ್ಳಿ, ಬ್ಯಾಕ್ ಪೋರ್ಷನ್ ಅವ್ರು ಕೊಡಿ. ಎಸ್ ಎಸ್ ಇನ್ಯಾರಿದ್ದಾರೆ? willing to accept the hind portion? Yes, ಮುಗಿತಲ್ಲ. ಮತ್ತೆ ಮುಗಿಸ್ಕೊಳ್ಳಿ. tomorrow. Measurement correct ಆಯ್ತು. ಇಲ್ಲ ಮೆಜರ್ಮೆಂಟ್ ಕರೆಕ್ಟ್ ಆಯ್ತು. ಇನ್ನು ಕೇಳದೆ ನಾಳೆ tomorrow. ನಿಮ್ಗೆ ಹಿಂದಿನ ಭಾಗ ಅಂತ ಆಯ್ತು, ಇನ್ನೇಕೆ ನೀವು ಬೇರೆ ಕೊರಗ್ತೀರಿ? ಆಯ್ತು, ನೀವು ಹಿಂದಿಂದ ಅಂತ ಹೇಳಾಯ್ತಲ್ಲ, ಮೆಜರ್ಮೆಂಟ್ ಫಿಕ್ಸ್ ಆಯ್ತು, ಹಿಂದಿನ ಪೋರ್ಷನ್ ಸೆಕೆಂಡ್ ಪ್ರಾಪರ್ಟಿ ಆಯ್ತು. ಇನ್ನೊಂದು ಯಾವ್ದು? ಅದನ್ನ ಹೇಳ, ಅದನ್ನ ಕಮಿಷನರ್ ಹತ್ರ ಮಾಡಿಸ್ಬಿಡ್ತಿದ್ವಲ್ರಿ. ಯಾವ್ದು ಇನ್ನೊಂದು ಯಾವ್ದು? ಹಾ ಹಾ ಹ್ಮ್ ಮೈಸೂರು ಅವ್ರದ್ದು ಅವ್ರಿಗೆ ಕೊಡಿ ಹೋಗ್ಲಿ. 1 and 2 ಅವರು ಕೊಡಿ, 3 and 4 ನೀವು ತಗೊಳ್ಳಿ. ಮೈಸೂರು ಅವ್ರದ್ದು ಇವಾಗ ಕನ್ಸರ್ವೆನ್ಸಿ ಕಡೆ ಅವ್ರು ತಗೊಳ್ತಿದ್ದಾರೆ. ಇಲ್ಲ ಒಂದು ಕೆಲಸ ಮಾಡಿ ಸರ್, ಇಲ್ಲ ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಕನ್ಸರ್ವೆನ್ಸಿ ನೀವು ತಗೊಳ್ಳಿ, 1 and 2 ಶಾಪ್ ಮೈಸೂರು ಅವ್ರು ನೀವು ತಗೊಳ್ಳಿ. ಖಾಲಿ ಮಾಡಿ ಸರ್, ಖಾಲಿ ಮಾಡಿ. ಲಿವಿಂಗ್ ಇನ್ ಎ ಪ್ರಾಪರ್ಟಿ ವಿಚ್ ಇಸ್ ಕನ್ವೀನಿಯಂಟ್ ಯು, ನೋ ಡಿಸ್ಪ್ಯೂಟ್. ಭಾಗ ಆಗ್ತಾ ಇದೆ, ಭಾಗ ಆಗ್ತಿದ್ರೆ ಮೈಸೂರು ರೋಡ್ ಫೇಸಿಂಗ್, ಇಫ್ ಯು ವಾಂಟ್ ಮೈಸೂರು ರೋಡ್ ಫೇಸಿಂಗ್ ಬೇಕು ಅಂತ ಅಂದ್ರೆ ಫಸ್ಟ್ ಐಟಮ್ ಅಲ್ಲಿ ಮೇನ್ ರೋಡ್ ಬಿಟ್ಕೊಡಿ, ಡಯಾಗನಲಿ ಇಲ್ಲಿಂದ ತಗೊಳ್ಳಿ, ಇದು ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. ಪರ್ಸನ್ ಥರ್ಸ್ಡೇ ಲಾಸ್ಟ್ ಡೇ ಆಗಲ್ಲ ಸರ್, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಊರಿಂದ ಹಂಗೆ ನಾಳೆ ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗಿ ಸರ್, ಮುಗಿಸ್ಕೊಂಡು ಹೋಗಿ. ಥರ್ಸ್ಡೇ ತುಂಬಾ ಶಾರ್ಟ್ ಆಗ್ಬಿಡುತ್ತೆ. ನಾವು ಧಾರವಾಡಕ್ಕೆ ಹೋಗ್ಬೇಕು, ಅದೆಲ್ಲ ಮುಗಿಸ್ಕೋಬೇಕಲ್ಲ. ನಾನು ಧಾರವಾಡಕ್ಕೆ ಹೋಗ್ಬೇಕು, ಇದೆಲ್ಲ ಇಲ್ಲೇ ಮುಗಿಸ್ಕೋಬೇಕು ಸರ್. ಐ ಕಾಂಟ್ ಕ್ಯಾರಿ ಟು ಧಾರವಾಡ, ಇಲ್ಲೇ ಮುಗಿಸ್ಕೋಬೇಕು ನಾವು. ನಾಳೆ ನಾಡಿದ್ದು ವಿ ಮಂಜುನಾಥ್. Who is this man? ಬರೀದೇವ್ರನ್ನ ಏನ್ ವಕೀಲರಂದ್ರೆ ಏನ್ ಅನ್ಕೊಂಡು ಮೈ ಮೇಲೆ ಕೈ ಮೇಲೆಲ್ಲ ಹಾಕೊಂಡು ಹೋಗೋದು? Have some respect, mister. He is dealing with your problem. Respect him. Yes. They are Manjunath, Manjunath. Huh? Yes, what is the suit for? Ejectment. ಏನಾಗಿದೆ?
So we made a presentation for commissioner. After now, we spoke to what was the the Shagara Gogina Gogina Patra, Gogina Patra,
So now
Correct. Agreement to mortgage ಎಲ್ಲ ಇರುತ್ತಾ?
immediately they wanted to know what.
We consider it as an agreement. Agreement to mortgage. Is it an agreement to mortgage? You file a suit for special performance. Clearly. So what is that you have filed application now? ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರಿ? The document was marked. The agreement was marked. Yes, Mr. There is no representation for the respondent as a last chance discount. You could not be extended the next state of hearing. ಯಾವ್ದು ಇತ್ತು ಯಾವ್ದು ಪೂರ್ವಸ್ಥಿತಿ ಇರ್ತದೆ ಯಾವ್ದು? ಎಷ್ಟು ಬಿ ರಮೇಶ್ ಏನಿದು ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಯ್ತು? ಏನು ಆಗಿದ್ಯಾ ಇಲ್ವಾ? ಯಾವತ್ತು? Council for the petitioner list on Thursday. Interim was extended till the next state of hearing. Yes, ಏನು ಇಲ್ಲಿದ್ದಾರೆ? Where is the other side? Yes, Mr. List to tomorrow. No, list tomorrow. Only list to tomorrow only for the amount alwa ಎಷ್ಟು ಅಂತ? ನಮ್ಗೆ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಇದೆಲ್ಲ? 2022 writ petition, there is 2015, 16, 17, 18, people are waiting. I know. Come at 2:30. Yes, Mr. Attachment before judgment. Attachment. No. The court has to first call upon the person to furnish security. On his failure to do so, the attachment will be issued. You cannot issue attachment and say, it is a law declared by this court. All interim orders are extended. 71. ಅಲ್ಲ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗಿಸಿದ್ರಿ ಅಂತ ಹೇಳಿ all other matters should be taken. ಯಾರು ಕರೀರಿ ಯಾರು? ಸರ್ ನೀವೆಲ್ಲ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ ಸರ್? ನೋ ನೀವು ಅಡ್ವೊಕೇಟ್ ಬಂದು ಕೊಟ್ಟಾಗ ಪ್ಲೀಸ್ ಡೋಂಟ್ ರಿಫ್ಯೂಸ್ ಟು ರಿಸೀವ್ ದ ನೋಟಿಸ್. ದಯವಿಟ್ಟು ಇದನ್ನ ರಿಪೀಟ್ ಮಾಡಬೇಡಿ. ನಮಗೆ ಕೋರ್ಟ್ ನವ್ರದ್ದು ಕೆಲಸ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಕೊಡೋ ಉದ್ದೇಶ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಬೇಗ ಕೇಸ್ ಮುಗಿಸೋಣ ಅಂತ ಅಷ್ಟೇ. ಅಲ್ಲೇ ಇದಾರೆ ನೋಡಿ ಅಲ್ಲಿ. ಮಿನಿ ಇದಾರೆ ನೋಡಿ ಇಲ್ಲಿ. ಅಲ್ಲ ಇವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ, ಇವ್ರು ನಿಮ್ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಇದಾರಲ್ಲ. This is the first time you are appearing. ಹೋಗ್ಲಿ ಬಿಡಿ. ಬನ್ನಿ ನಮ್ ಚೇಂಬರ್ ಬನ್ನಿ, ತೋರಿಸ್ತೀವಿ ಬನ್ನಿ. ಬರ್ಕೊಳ್ಳಿ. Learned counsel for the petitioner. ಯಾವ seal number? 76. Learned counsel for the petitioner submits that the writ petition has become infructuous. So the submission is placed on record and the petition is dismissed. The presence of Mr. Ramachandra, Yan Ramachandra has noticed, who has expressed remorse for not accepting the notice of the court. Stop. Yes. Go to the post of the main mistake. Go to the. Whatever date that the court officer gives you.
Court officer. Court officer. Sir, serial number 66 interim order extend on the. Court officer.
Court officer. Serial number 52. Court officer. Court officer. Oh, I don't do it. Court officer, serial number 52.
Sir, 66 serial number.
ಯಾವ್ದು ಸರ್?
66.
66. ಯಾವತ್ತು ಸರ್?
19738.
ಸರ್ ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ?
Sir, next month, any date.
ನೆಕ್ಸ್ಟ್ ಮಂತ್ 21st October.
Okay, sir. Interim order
Sir,
extension.
serial number 52.
ಆಗುತ್ತೆ ಸರ್, ಆಗುತ್ತೆ ಸರ್.
Okay, thank you.
Sir, serial number 52.
52.
52. ಅದೇನಾಗಿತ್ತು ಸರ್ ಇವತ್ತು?
ಸರ್ DNP. Dismiss for non-prosecution.
Okay. Okay.
Sir, 66 ಇನ್ನ ಲಾಂಗ್ ಡೇಟ್ ಏನು ಸಿಗತ್ತಾ? 21st ಬೇಡ, 21st ಆದ್ಮೇಲೆ.
66 ಸರ್ ಇನ್ಯಾವ್ದು ಸರ್? 21st October.
Okay, okay, thank you. Thank you, sir.